May I beg a lordship? My lord, I beg to mention item number 56, my lord, supplementary list. In this matter, my lord, I have to file an affidavit, my lord. And the affidavit is ready, but the petitioner is to come to sign the affidavit. So I have informed my learned friend, Mr. S.K. Talukdar, standing counsel for cooperation, my lord. May kindly-
How much time you need?
2 weeks time, may kindly be done.
Okay. Affidavit in reply or what?
My lord, affidavit for division of response number 8.
Then that will be IA or what?
My lord, affidavit,
Deletion of response number 8.
my lord.
That will be IA.
That will be IA, man. IA होगा तो क्या क्या affidavit deletion बोलो.
My lord.
Okay, Mr. A.R. Talukdar, learned counsel for the petitioners, has sought for 2 weeks' time to file an interlocutory application for deletion of the name of party respondent number 8 from the array of respondents. Post of Mr. S.K. Talukdar, learned standing counsel cooperation department, and Ms. M. Borman, learned junior government advocate for the state respondents are present. In view of the above submission made by Mr. In view of the prayers from it, let the case be listed after 2 weeks, on a date 2 weeks, after 2 weeks.
Oh, please.
May I please, Your Lordship? I beg to mention item number 20, Lordship. In this case, what when the respondent number 7 has filed the affidavit of opposition, we want to file rejoinder. So already
Item number?
item number 20, Lordship.
Industry.
Yes, industry.
Okay, you are for the petitioner.
Petitioner. Lordship.
Okay, yes, what do you want?
Let it come on on June 16, Lordship, the hearing date. It can be disposed of on that day. Sir.
What is your prayer?
We want to file reply to the rejoinder
Okay,
filed by the respondent number 7, Lordship.
Not some on another date then. Okay, 16. Ms. R. Bora, counsel for the petition has sought for 3 weeks' time to file an affidavit in reply to the affidavit in opposition filed by the
Respondent number 7, Lordship.
number 7. Post of it is submitted and consent has been taken from the learned counsel for the respondents to make the prayer. You have informed the other side?
Yes, yes. We have
Okay.
informed. Government also, Lordship.
The prayer is allowed, list the case on so 16-6.
June 16,
16-6.
of like.
May please. My lord, I apologize for any inconvenience caused in respect of item 3, my lord. I am appearing in this case, my lord, but since the name did not, my lord, reflect my name, inadvertently, my lord, I missed the item. Tomorrow,
Let us wait.
my lord.
Item 3.
My lord.
Please, my lord, I am praying for listing of orders for withdrawal tomorrow. My lord.
Well, tomorrow.
Please, Lordship.
Wait.
My lord. My lord, regarding item 10 and 11, my lord, this is a motion case. Yesterday, the information has come, some subsequent development regarding issue of issuance of NOC, my lord, has come place. The party wants to take some instruction from the department, my lord. 1 week time maybe.
Okay. On the prayer of Mr. A.Y. Chaudhary, learned counsel for the petitioner, list the case on so and so. Mr. Who is revenue? A. Authorised, revenue.
Yes, my lord. Yes.
I am Borman.
22 का date.
हाँ लिखी दी बस status. Junior government लिखी दी बोल are present.
5th June.
10 and 11.
May 0506. With regard to item number 30 and 31, Your Lordship. You have to file a reply, Your Lordship, against the affidavit filed by the respondent number 7, Your Lordship.
30 and 31.
Adjournment-
There is a mention memo
Yes,
already.
Your Lordship, already circulated on Friday.
Okay, Mr. You want to file an affidavit in
Reply.
reply? Okay.
Against
Mr.
the-
A. Das, learned counsel for the petitioners, has got for and is granted. How much time?
3 weeks, Your Lordship.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the
Respondent number 7.
respondent number 7. Post of Ms. M. Borman,
Regards.
state respondent junior, and A. Authorised,
Yes, my lord.
DCL, R. Bora, pending counsel and DCL for the respondents are present.
Obliged, Your Lordship.
List the case on so and so.
1906.
Similarly, 31 also.
Okay.
I mentioned memo to that effect has already been circulated yesterday. Huh?
May please,
30
Lordship.
and 31.
Your Lordship, with the consent from the other side, I beg to mention item 54 of the supplementary list.
54.
4 of the supplementary list.
You are for?
I'm for NC Hills. We've sent our affidavit for waiting, so your lordship may
You're
give
for
us 2 weeks.
petitioner or respondent?
I'm for the respondent, your lordship.
Respondent means Carbiang and Seals.
Yes, NC Hills, your lordship.
You're for
Petitioner.
Mr.
IL Ngamlai on behalf of Vivaru.
I.L.
Ngamlai on behalf of Vivaru.
Long My Lai.
No, IL Ngamlai.
Learned counsel for the petition is valid.
54.
Miss,
Miss PCA, on
Please.
behalf of RM Das.
on behalf of Mr. R.M. Das, Learned Standing Counsel, NC Hills Autonomous Council. For the respond number,
Respondent number.
you want time for what?
Your lordship, we've sent our affidavit for waiting.
Okay, have submitted that what is the respond number? Respond number. Have sought for,
1, 2.
has submitted that the draft affidavit opposition has been sent for waiting and has just sought for listing of the case after
2 weeks.
2 weeks. In order to file the affidavit in the meantime, the prayer is allowed as the prayer is made with the consent of the, as the request is allowed as the same is made with the learned counsel for the respondents. So probably is the case on switch.
Lordship,
If-
date may be.
15 June, 1506.
Much of
There is an interim order.
The interim order silo. Yes.
May Lordship. Lordship, I beg to mention item number 42, Lordship. So here in Lordship, I would like to file one additional affidavit, Lordship. So on that way, Lordship, matter may be
Review.
taken up day after tomorrow or Friday, Lordship, if possible, Lordship.
On the request of Mr. R.C. Das, learned counsel for the petitioner, is the case on Friday.
Yes, Lordship.
Friday.
Must have.
May I please, your lordship? May I please, your lordship? But I wish to mention item number 21, my lord. In this case,
21?
my lord, I have to, 21, my lord. I have to file affidavit in reply, opposition filed by response number 3, my lord.
Mr. T. Sheikh, learned counsel for the petition has sought for and is granted. How much time? 3 weeks time to file an affidavit in reply to the affidavit of eviction filed by the
Response number 3, my lord.
respond number 3.
Filed of it.
List the case
21.
after on so and so.
1906.
Counsel लिख दियो.
I beg to mention item number 39 and 34.
Item number?
39 and 40. My senior counsel, he is not well.
Hmm?
My senior counsel, Dr. A. Todi, he is not well. Then,
Not well.
yes.
Miss
M. Parvin.
M.
Parvin,
Parvin, learned counsel for the petition has sought for listing of
the day.
has sought for listing of has sought for an adjournment of the case for the day on the ground that Miss Dr. A. Todi, learned counsel, who is leading her in this case, is indisposed. You have informed.
No, Lordship.
You have informed.
No, Lordship.
Then you should inform. They will keep this.
Lordship, item number 30 and 31, can it be on 22nd instead of 19th?
Okay. You inform,
Much obliged, your lordship.
madam.
May I please, your lordship? My lord, I beg to mention for listing of an admission matter, my lord, on 3rd of July, my lord, 3rd of June, my lord.
What is the urgency?
Urgency, my lord, petitioner's license has
21.
been suspended, my lord. Petitioner's license has been suspended. License,
30.
License of what license?
my lord, he is a government believer, my lord.
Let it be according to the court business.
I
You give it.
beg to mention a case, my lord, of 2030, my lord, for admission hearing this Thursday.
This Thursday. This Thursday is a holiday.
Next Tuesday, my lord.
That depends. What is the subject matter?
The jurisdiction of an FIR, my lord,
Jurisdiction?
of an FIR.
Give it to the court master, he'll try to accommodate.
Okay.
My page, Lordship. Lordship, I beg to mention for listing of read petition, Lordship. For motion, Lordship.
Motion.
Yes, Lordship.
What is the subject matter?
Subject matter, Lordship, opposite party during the proceeding. With the
Opposite party?
opposite party during the proceeding with fake signature, Lordship. I am the ex-secretary and BOD member, Lordship. They have to do, Lordship. Obliged.
Okay.
Your lordship, I beg to mention item 38. As we have not filed an affidavit, therefore we kindly adjourn the matter for today.
38. You want to file affidavit?
Yes, Lordship.
Huh?
Lordship.
You are informed.
Yes, Lord.
Yes, Lordship.
Mr. S.K. Saha, learned counsel for the petitioner is present. Miss
Gayam Jijong.
learned counsel on behalf of
Number two.
Dr. B.N. Gogoi.
Dr. B.N. Gogoi, learned standing counsel CGST, has sought an adjournment of the case for 2 weeks in order to file affidavit.
Lordship.
Okay. As sought for, release the case. Sought for adjournment of what time? 2 weeks, 3 weeks?
Lordship.
You'll be able to know
After 1 week.
after 1 week. Possible.
Okay, 2 weeks.
Do you have any instruction?
We have not received any instruction till
Then
Okay.
gap rakhi. Take instruction from your senior,
Lordship.
then say after what week.
Lordship. Yes, Lordship. Thank you.
Release the case on so and so. Accordingly, the interim order, if any, shall continue till then.
May I
Lordship.
Lordship, I beg to mention for listing, read petition for admission.
Subject matter,
Subject matter for immediate relief, for,
you should know before mentioning. Come tomorrow.
Okay.
After going through the brief.
Supplementary list for withdrawal. Item 51. Please, Your Lordship. My lord, subsequent development is there. I have the instruction to withdraw the petition.
Mr. M.I. Hussain, learned counsel for the petitioner, has submitted that in view of subsequent developments, the petitioner wants to withdraw the writ petition.
With liberty.
With liberty. Also, Miss M. Bormon, learned junior government advocate, or Mr. A. Authorised.
My lord.
A. Authorised revenue 1
Yes, my lord.
and M. Bormon, learned junior government advocate, Assam for the respond number 2, 3, and 4 are present. In view of the above submission made by Mr. Hussain, learned counsel for the petitioner, the petition is dismissed and withdrawn, with liberty, as prayed for.
Daily list for motion. Item number 1.
Yes.
I'm appearing for the petitioner, my lord. If your lordship could kindly turn to page 21. There's a show cause notice which is being impugned by the means of this petition.
31.
21, my lord.
21.
Your lordship will kindly produce the first paragraph.
Yes.
My lord, in the last 2 lines of the first paragraph, your lordship will see this is essentially an exemption dispute. The amount involved is 15.04 crores and the period under consideration is July 99 to November 2002. Now, your lordship will kindly turn to page 23. This is the last page of the show cause notice. Your lordship will see at the bottom, the date of the show cause notice is 7th June 2007. So it's been pending for about 19 years. Now, if I take your lordship to page 111,
Yes.
your lordship will see this at page 111, there's a judgment of this honorable court, the honorable division bench. And in particular, your lordship will see paragraph 3 and the amount and the period mentioned there.
Just a minute.
Yes.
There is another notice earlier.
Yes, my lord. So I just want to place on record the status of different. This is basically a case of a duplicate show cause notice.
Okay, just a minute.
Yes, ma'am.
Yes, 2003 notice. What happened there?
Yes, my lord. And now, if your lordship sees the tabulation which I have presented,
It was dropped or what?
yes, my lord. All these show cause. So the entire dispute on the 15 crores was set aside. So if your lordship sees the tabulation, I'll give your lordship a brief history. So if your lordship sees row number 1, so July 99 to May 2002, that was the very first show cause notice for 12 crores. A show cause was issued in 2002. Then by an order in original, the adjudicating authority dropped the show cause notice. The department filed an appeal, which the tribunal dismissed in the year of 2005. This is the year when the eligibility issue was finally decided. And the department never preferred an appeal against this 2005 tribunal order. Now, subsequently, what happened is, in row number 2, your lordship will see, for an overlapping period for July 1999 to November 2002, they issued a show cause notice for 15 crores on the same issue. And this, here again, the adjudicating authority dropped the show cause notice on the ground that the tribunal had already decided it. The department preferred an appeal before the tribunal, and the tribunal again, drawing reference to their 2005 order, dismissed the second appeal of the department. The department again filed an appeal before the division bench of this honorable court, culminating in the judgment which was delivered in 2024, which I just showed your lordship in page 111. Now, again, on the same issue, they had issued a triplicate show cause notice, which is in page 21 for the same period and the same amount. And so what the assessee is seeking to achieve before this honorable court by means of this petition is to bring an end to the multiplicity of proceedings.
Yes, Mr.
Lordship has seen the notice issued in 2007. Then Lordship page 26.
First notice was okay. This is of 2007,
2007.
which is impugned here.
Yes, Lordship.
Yes.
Lordship, regarding
This is what?
correctness of the issuance of notice, I'm not on that. I'm placing the Lordship how the petitioner.
Page
26.
26.
After in 2025, notice for personal hearing was issued. Then Lordship page 27.
Yes.
It is a letter dated 16 September 2025 by the petitioner to the Commissioner Dibrugarh Lordship. But I want to place paragraph 1, Lordship. By this notice of hearing under reference, a personal hearing has been fixed in the subject adjudication initiated by the show cause notice dated so and so. For ready reference, a copy of the said notice of hearing being enclosed herewith. In this regard, please note that we do not have in our possession any such copy of show cause notice.
Which paragraph you are reading?
Paragraph
Page?
Page 27, Lords.
Okay, my notice of hearing under reference on 79.
One side they are sitting there, they had
Even a copy of the said notice of hearing is being enclosed here. So yes, please read.
Paragraph 2. In this regard, please note that we do not have in our possession any such copy of so cause notice referred to herein above, and will be grateful if if the same could be made over to us at the earliest. Since our factory is in Jorat, Assam has been closed. We can no longer be contacted at the aforesaid address and no longer have any staff present there and can visit your office in the present time. In the premises, in the aforesaid requested the notice or communication be made over to the following address. I'm at this stage, I'm not on the correctness of the notice of 2007 Lordship. I'm showing how the petitioner is taking the proceeding Lordship. One side they said they don't have any copy of the notice and they are annexing copy and challenging the same.
Maybe they have found out later on.
No, Lordship, they requested
Question is about your conduct also.
No, Lordship, correct.
Your conduct is seriously in question.
No, Lordship, here, Lordship, initially I said that I'm not on the correctness of the notice.
Right. If two notices were earlier issued.
No, definitely, Lordship will.
Right.
If it is there.
Then why the authorities should be busy?
No, Lordship, it was issued in 2007. They may not be aware about the.
So that cannot be a ground. There is a judgment already.
No, Lordship, there. I appeared in before the.
Yes, there is a judgment also.
I'm aware of.
Where.
Lordship, in this case, what happened for last more than 7 years, nobody appeared. Then the notice was published in newspaper. Therefore, they appeared in the.
They have said they have closed the factory.
Yes, Lordship. Initially, Lordship, that was. They said that they shifted the India in Gauhati.
What is the so-called notice?
No, Lordship, I'm not the correctness of the notice issued by the authority.
Now come to paragraph 7 of the judgment, 113. The show cause notice in relation to the period running from July 1999 to May 2002 was issued on 2002. I think that is the first one.
This is the first one.
Where 12 crore something was demanded. Right?
Lordship.
Whereas show cause notice relevant to the present appeal was issued on 5/9/2003, which was in relation to the period July 99 to November 2002. Admittedly, the subsequent show cause notice includes the period, same period, for which Sestat has already passed an order in favor of the respondent, which has attained finally. Therefore, it is not open to the revenue to again hesitate the said issue by way of issuing a fresh show cause notice. The action on the part of not challenging a decision in relation to which includes subsequent show cause notice disentities on challenging it. Mr. Kal, this has to be given quietus.
No,
take your instruction.
That's why, Lordship, I initially said.
Now all materials are available with you also.
No, Lordship, definitely. I've already.
Same amount, same thing that has been buried.
Lordship, I've already.
In 2024.
I've already communicated to the
by the division bands.
They are looking after Lordship, if required, Lordship, the notice will be withdrawn. Because under the
better take a call.
Yes,
this is not
I'll
done.
just clarify what my learned friend has submitted. So if your lordship sees, so what had happened, the factory closed down. So they lost documents. So they had actually replied in 2007. If your lordship sees page 24.
It is my question, Lordship.
It was supposed to be withdrawn in 2007.
Whatever. So the period in the second show cause notice,
yes, Lordship, period is,
and this third show cause notice is same.
Lordship, it was issued in.
The demand amount is same.
Yes, Lordship, correct.
When the second show cause notice has culminated in a judgment,
yes, Lordship,
of the division bench.
Yes, Lordship, it is correct.
Right.
It was
against the revenue. And that has attained finality also.
Yes, Lordship.
Not to speak about the earlier one.
Lordship.
Then
I'm not disputing everything.
Then take a call.
Yes, Lordship. That's why I'm submitting. That I'm
will not issue notice. This is not a case or it has to be closed.
Yes, Lordship.
Right now. Only exception that you will be granted sometime.
Yes, Lordship, correctly. That's why
take instruction.
Yes, Lordship, I have already communicated to the authority yesterday.
This is not a matter where you have to file an affidavit in opposition.
Not at all required, Lordship.
Yes.
Not at all required. Lordship, on 9th of June, Lordship.
Heard, Mr.
Chakravarti.
Full name, please. You're good.
Arnab Chakravarti.
A. Chakravarti, learned counsel for the petition. And Mr. S.C. Kyle, learned senior counsel
For one, Lordship.
and special counsel
CGST.
CGST for the respondent number 1. Anybody?
Nobody is there.
Miss Postov. Where is Mr. Dev Chaudhary? He is available.
Not available. But his name may be recorded.
Any central government council, please call. I do not want to pass any order in absence. Para, in this writ petition, comma, a show cause, demand comes show cause notice dated 7/6/2007. Dissemination, legality and validity of a demand come show cause notice dated 7/6/2007. Are questioned. Post of the in an impugned demand comes show cause notice, comma, the petitioner company has been asked to show cause, was asked to show cause. As to why action against it under the provisions of the Central Excise Act 1944 and the Central Excise Rules, comma 2002 should not be initiated against him. Post of the ground mentioned in the show cause notice is to the effect that the petitioner company, which had its unit at Gauhati, having Central Excise Registration Certificate number so and so, page 30/21, engaged in manufacture of aerated water falling under so and so of Central Excise Tariff Act 1985. Had wrongly availed the benefits under the exemption notification, comma, have wrongly availed exemption under the notification number 33/99 the CE dated 8/7/1999 as amended and submitted fabricated documents to the department to suppress the actual installed capacity and substantial extension of the installed production capacity. And consequently, comma, it had availed exemption in the form of erroneous refund to the tune of rupees 15,04,35,465 for the period from July 1999 to November 2002. First of it is a case of the petitioner that earlier on 3/10/2002, a demand cum show cause notice was issued on the same very ground, on the same ground, alleging that the petitioner company had availed a refund of rupees 12 crore 16 lakh 76,500 erroneously under the said notification for the period from July 1999 to May 2002 post op. However, the Commissioner of Central Excise had later on dropped the demand cum show cause notice alleging erroneous refund via an order in original dated 2003-2003 post op. Against the order in original dated 2003-2003, the department preferred an appeal before the tribunal, which came to be dismissed on 20/01/2005 post op. As no further appeal was preferred, the order, the petitioner company has contended that the order had attained finality post op. Para. Subsequently, another demand cum show cause notice came to be served upon the petitioner company dated 5/9/2003, alleging erroneous refund of rupees 15 crore 4,35,465 under the same notification for the period from July 1999 to November 2002 post op. The said second show cause demand cum show cause notice was also dropped by the Commissioner of Central Excise on 28/02/2006 based on the order dated 20/01/2005 of the tribunal post op. Aggrieved there by the order dated 28/02/2006, the department preferred an appeal, C EX appeal number 3/2019. After the department's appeal was rejected by the tribunal by an order dated 13/3/2018 post op. The department's appeal, CEX appeal number 3/2019, came to be dismissed by a division bench of this court by a judgment and order dated 19/9/2024 post op. It is stated that against the judgment and order dated 19/9/2024, the department has not preferred any appeal till date, meaning thereby it has attained finality post op. After the aforestated first demand cum show cause notice dated 3/10/2002 and the second demand cum show cause notice dated 5/9/2003, the third demand cum show cause notice was issued on 7/6/2007 post op. Para. From the aforestated events, on a comparison of the second show cause notice and the third show cause, the second demand cum show cause notice and the third impugned, the third demand cum show cause notice, impugned in this petition, there is a distinct similarity in respect of the demand made to the extent of rupees 15 crore 4,35,465 and a period in respect of which such demand has been made, that is July 1999 to November 2002, first of para. In view of the aforesaid similarity, Mr. Carroll and his senior counsel and special counsel CGST shall obtain instruction as results as to why the third demand comes show cause notice dated 7/6/2007 is sustainable in law. Full stop. Mr. Cal has sought for listing of the case on 9/6/2026.
My lord,
Full stop. Having regard to the facts projected above, it is ordered that till 9/6/2006, the respondent number 1 shall not act any further on the basis of the third impugned, on the basis of the third demand comes show cause notice dated 7/6/2007.
my lord, a small indulgence. The date fixed as 9th June, if it may be kept on 10th, I consulted with my lord.
Okay, 10th.
Yes, very great.
You need any copy?
What's the one extra copy?
Okay. Mr.
Extra copy.
Okay. The learned counsel for the petitioner shall furnish a copy of the writ petition and are going to annex her to Miss
M. Kaput.
M. Kakoti. Okay. Assisted by Likidibu, assisted by during the course of the day.
Not so.
Deeply obliged.
Item 2.
May it please your lordship. May
Yeah.
it please your lordship. I am appearing from item number 2, your lordship.
Yes, please.
Lordship, page 14 may kindly be looked into, lordship. I have been served with the eviction notice, your lordship. So eviction notice is served on the husband, your lordship. So I am the wife, your lordship, because the husband is residing abroad, your lordship. And your
No
lordship,
way we can consider this to be maintainable.
lordship.
This is to be dismissed in limine. What right you have, not to speak of fundamental right.
Lordship.
Show me any semblance of any legal right.
My lord,
You can only ask for 7 days or 15 days, whatever it may be.
So, my lord, my respectful submission is rested on your lordship. So, my father-in-law have been residing in the state plot of land.
When, sir?
Lordship, for a long 40 to 45 years, your lordship, he was a government
So you have
servant.
owned a quarter?
Yes, your lordship. My
Yes,
father-in-law.
you have owned a quarter.
Yeah, it is a government land, your lordship. I am not denying the fact, your lordship.
It is a bungalow or what?
It's a
Quarter,
small, your
quarter.
lordship. It was a small quarter, your lordship. So
Good.
after the death of my
So
father-in-law,
after the death of your father,
father-in-law, your lordship.
what right you have? Father-in-law? What right
Yes,
you
your
have?
lordship. So
Your
after-
husband stays in Saudi Arabia
Yes, your lordship.
and you are in occupation of a government quarter. Since when did your father die, father-in-law?
Father-in-law, your lordship. Lordship, page 12 may kindly be looked into, lordship. Annexer 1, your lordship. Page 12. So you have applied for your lordship.
Sir,
For
this
that-
is public premise. This is This kind of application is not maintainable.
So
This is a public premise which is to be dealt with under the Assam Public Premises Act. Public Premises Eviction of Unauthorized Occupants Act. You nowhere come near.
So,
Nowhere
Lordship,
come near.
so Lordship, my respectful submission is that, Your Lordship, without there being any rehabilitation, Your Lordship, since I am a
You
landlord
want
person,
rehabilitation? Mr. Counsel, Mr. Dewan.
Lordship. So I don't have any land, Your Lordship. So I am, so I have
Go
been
and
living,
stay in Saudi Arabia. Don't
my husband, Your
don't
Lordship.
occupy a government quarter. Stay in Saudi Arabia,
Lordship.
where your husband is staying. You are occupying a government quarter for last 30, 40 years without paying anything.
No, Lordship, we have applied for Your Lordship.
Hard, Mr. A. Dewan, learned counsel for the petitioner. Where is Mr. Call Mr. Anupai. Call Mr. Anupai. I will not delay it. After some time, let all the respondents be here.
Irrigation, SC irrigation name is not shown also.
So call him. I'll not, since I have exercised the mind, I'll
Lordship.
dispose of right now. Call him.
Okay, sir.
Lordship.
Public resources. When your father died, father-in-law, tell me, was he a class
Lordship,
4?
I have subsequently, I have filed an additional affidavit.
Okay,
also.
good.
So, Your Lordship, page 18.
Just a minute.
Page
What is the
18,
date of retirement of your father-in-law? Okay. He expired.
Yes, Your Lordship. After
When?
that, yes, Your Lordship. So after the death of my father-in-law, Your Lordship, my husband have been residing in the said plot of land because of the fact that, Your Lordship, there is no land in question, Your Lordship, for shelter, Your Lordship. So finding no way out, Your Lordship, they have been residing for long without any interruption, Your Lordship, from any quarter. Even subsequently, we applied for to the government, Your Lordship.
And
So, Lordship,
I'll hold that state respondent shall realize all pending dues by taking whatever possible measures available under the law. Collect the date of birth of your father-in-law. And since when your husband is in Saudi Arabia?
Lordship.
Okay, next.
Item 3.
Yes, something was mentioned in the morning. Yes, what is the issue here?
Lord, I am also praying some sort of accommodation, but issue is that, my lord, petitioner is a president, my lord, of a Gaon Panchayat, and district commissioner disqualified her, my lord.
Huh?
After the election as a president, my lord, that was my lord, reverted back by the district commissioner, and that was challenged in a writ petition, my lord.
Who claims to have been elected in a district and special president despite being elected president. Activation of digital signature.
That was cancelled, my lord, by district commissioner.
Why?
My lord, page 55, I think, well, this is the impugn order of another writ petition, my lord.
55.
55.
Election of presidents.
DC exercise under section 11, my lord.
Aisa Begum. respondents, order. Election of president.
Yes.
Then
Under section 11 of the Act, my lord, DCI has exercised his power, my lord.
111 or 100?
11, my lord. Section 11.
Oh, section 11. Court. Okay, two persons contested.
One Suranjana Begum Tapadar and
On
Ayesha
marking
Begum.
manner where a cross mark overlaid between the spaces allotted to both candidates. So is declared duly elected.
That order
Okay.
of the district commissioner has already challenged by the petitioner. That was the writ petition number 5253 of 2025. Annexer 63, Annexer 963, page 63. 5253 of 2025.
5253 of 2025.
Page
Challenge.
63. Yes.
Page 63.
Yes, my lord. And operating part, my lord, page 66. In that case, my lord, the status quo was passed, my lord.
Status quo was passed.
Yes.
On what ground notice be issued?
Say third last and second last, maybe.
Provision to board, that the deputy commissioner order was subsequently order of this court.
Yes. Thereafter, my lord, after the district commissioner's order, this order was passed, my lord, where that was challenged.
Now, what is the prayer Mr. Talukdar was making at 10:30?
My senior is in legs on court number 1.
What prayer he was making?
My lordship, I have no idea about
My lord, he told me, my lord, because he missed the matter, my lord. So he also wants some, my lord, accommodation, my lord, and some written instruction. I am also waiting, my lord.
Okay. A request has been made by Mr. S.K. Talukdar and it counsel for a petition for listing of the case in the next week. So a similar request is also made by Mr. S. Dr. Senior Standing Counsel, Panchayat and Rural Development Department to obtain instructions, relevant instructions in the meantime. In view of the prayer submit, let the case be listed on. So next week. Yeah, the video.
5-6, my lord.
Item 4.
I love Liza.
Division of names from tenants from Peter records. This is the same. In issue notice. Yes, Miss Bond.
This copy I have received today morning.
So you saw the deletion of names.
Yes, my lord.
One, I'm sorry, my lord, today morning I have received this copy. It's not a better one, my lord. Miss case has been disposed of, my lord, by speaking order, and it is now sent to ADC for approval, my lord, for striking the name.
For
Striking the name.
speaking order. You are Veena Chand.
Yes.
Been-
So Miss case has been disposed of.
Disposed of on 15.
As a concerned, LRA report submitted during a period of swing.
For approval, it is sent to the concerned ADC, my lord,
This year,
on 9 October 2020.
and in the forwarding letter, what is there?
That it has been forwarded for approval to the ADC, my lord. Prior to this disposal, my lord, on 9 October, that Miss case has been.
Names are there, 9th October. What is the proper paragraph regarding Veena Chand? According to the legal heirs of Authorised have been in possession of along with having considered mentioned that legal heirs of India has land. Dulal Kumar Chand? Your husband's name Dulal Chand?
Yes, my lord.
Huh?
Yes, my lord.
Dag number 66, Patta number, Patta number 66, Dag number 171.
Yes, my lord.
Okay. Dag number 66. Whose name was incorporated in your
Yes, my lord.
ORD?
Ashraf Ali and Fuljan. And your lordship will-
Ashraf Ali?
and Fuljan, wife of Ashraf. Your lordship will find page
You
number.
can write. Ashraf Ali. Thereafter, Fuljan Nisa.
Yes.
So he has submitted a report regarding striking out of Ashraf Ali Fuljan Nisa.
Lord.
Now it needs the approval of.
Waiting approval for ADC, my lord. It is SAN.
Dispose of this miscase has been disposed of by a speaking order, and matter has been submitted before the additional district commissioner revenue to take appropriate action on the basis of the report. So let him
Lord.
take a decision within a period of 6 weeks.
Some time frame may be given.
6 weeks.
Lord.
Can I get the disposal order?
You give a copy of this so that he can pursue.
Yes, my lord.
Heard
Ah,
Mr. R. Islam, Learned Counsel for the petitioner, Mr. A. Borsaji, Learned Standing Counsel, Revenue Department for the response number 1 through the virtual mode, and Ms. M. Borman, Learned Junior Government Advocate for the response number 2 to 5. Post of para. the petitioner has stated that her deceased husband, Dulal Kumar Chand, was a recorded patadar and owner of a plot of land measuring 2 kathas, 15 lessers, covered by Dag number 171, Roman and Patta number 66, situated village Bamunpara, part Roman 5, within bracket town, Bilahipara Revenue Circle, Bilahipara, District of Assam, subject plot. Poster. The petitioner has stated that the name of Dulal Chand was mutated in the land records mutated in the land records mutated in respect of the subject plot in the revenue records by way of inheritance. Stop. Dulal Kumar Chand expired on 9/12/2003. Stop. After the death of the petitioner's husband, the subject plot stood mutated in the name of the petitioner and her 2 sons. Stop. In support of the spectrum of ownership, the petitioner has enclosed a copy of the land holding certificate issued, holding certificate dated 23/7/2024, issued by the circle officer Bilakipara Revenue Circle, within bracket respondent number 5, wherein it is certified that the subject plot is in the name of the petitioner and 2 others. Stop. Para. This is the case of the petitioner that the names of 3 persons. 1, late Punjo De, son of late Katuram De. 2, Muhammad Ashraf Ali, within bracket respondent number 6, and 3, late Fuljan Nessa, wife of Ashraf Ali, have been mutated also in respect of the subject plot, showing them as permanent tenants. Also, the petitioner has contended that their names who were entered in the land records of the subject land in a fraudulent manner, as there was no tenancy agreement between these 3 persons and late Dulal Kumar Chand. Full stop. Para. The petitioner has stated that an application was filed seeking deletion of names of those three names, allegedly shown as tenants, from the CETA records pertaining to the subject land, full stop. On receipt of the application, comma, the respondent number 5 registered the same as Miss Case Number, ago order to say BPC stroke Miss stroke 363 stroke 2025. First of all, after registering the case, comma, the respondent number 5 issued notices to the opposite parties whose names stood incorporated in the CETA records as tenants. First of all, the petitioner has stated that on 15/7/2025, a hearing took place in connection with Miss Case Number so-and-so, but the respondent 5 did not pass any final order till date. With such projection, the petitioner had approached this court by the present writ petition. When the writ petition was moved on 15/5/2026, the learned junior government advocate was requested to obtain instruction whether any final order has been passed by the respondent of 5 in Miss Case Number so-and-so. And if passed, when such order has been passed, and if not passed, the time period in which the final order was expected to be passed. Today, Miss Bormon, junior government advocate appearing for the state's respondents, has submitted that the respondent of 5 has already passed a speaking order in Miss Case Number so-and-so on 15/10/2025. Full stop. By an office letter dated 9/10/2025, the respondent of 5 had also forwarded a land status report on the basis of the petitioner's application for striking out the names in relation to Miss Case Number so-and-so. First of from the documents placed by Miss Bormon, it transfers that in the speaking order and in the office letter supra aforementioned, the respondent of 5 has mentioned the events as regards transfer of the subject land measuring 2 kathas, 15 lesas to the effect that it was originally purchased by one Purnananda Rai from the legal heir of Amarendra Nath Chakraborty. Subsequently, it was sold by Purnananda Rai to Basant Kumar Chand, son of Ketu Ramchand, by the registered sale deed number 4621 dated 14/8/1974. After the demise of Basanta Kumar Chand, his legal heirs, 1 Dulal Kumar Chand, 2 Niranjan Kumar Chand, 3 Narayan Kumar Chand, all sons of late Basanta Kumar Chand, and 4 Kajoli Rani Chand, wife of late Basanta Kumar Chand, mutated their names by inheritance in the year on 28/6/1990. Full stop. The respondent of 5 has further reported that during the period, so the name of Tiken Rai, right?
Yes.
Yes.
During the period of revenue attestation, the name of Tiken Rai was struck off from DAG number 172 and was erroneously inserted as a tenant in DAG number 171 and Patta number 66 on 5/11/1995. Full stop. During the period of subsequent revenue attestation in the year 2008, the name of Ashraf Ali was recorded with Tiken Rai in the plot of land pertaining to DAG number 171 on the basis of a registered deed number 2240 dated 31/8/2004, whereby the land was shown to be sold by Tiken Rai to Ashraf Ali. Full stop. The circle officer, the respondent of 5, has further mentioned that earlier, Tiken Rai purchased a plot of land measuring 2 katha 10 lessa in DAG number 172 from one Bharati Bala Devia by the registered deed number 4199 dated 31/8/1984. Post stop. On the basis of the revenue attestation, the name of Ashraf Ali came to be mutated as a tenant in place of Tiken Rai in respect of DAG number 171 instead of DAG number 172. Post stop. Para. The writ petition has been preferred. Seeking disposal of miscase number BPC stroke so and so, and a communication of the final order passed therein. Post stop. As it is noticed that miscase number so and so has already been disposed of by the respondent number 5 by an order dated 15/10/2025. The relief sought in the aforesaid terms has been mitigated. Full stop. Para. The respondent number 5 by the office letter dated 9/10/2025 had forwarded the matter to the additional deputy commissioner within bracket revenue Dhuri with his report, which is with a lens data report for necessary action at his end as the matter of striking out of a tenant's name from the land record requires approval from the said authority. Post of Ms. Borman Learned Junior Government Advocate has submitted that the matter is pending before the additional district commissioner within bracket revenue Thuguri for grant of approval to strike out the tenant's name from the land record pertaining to the subject plot or otherwise. Post of before the district commissioner stroke additional. Post of as the matter is presently as the matter of striking out as the matter of grant of approval for striking out the name of the tenants from the subject plot is stated to be pending presently before the district commissioner Dhubri stroke additional district commissioner revenue Dhubri, Ms. Burman has submitted that the revision can be disposed of with a direction to the said authority to consider to finalize the matter within a reasonable period of time, and as per Ms. Burman, a period of 6 weeks will be sufficient for the said authority to finalize to bring the matter to a logical conclusion by accord of approval or otherwise. Post of Mr. Islam Land Council for the petitioner has agreed to the submission of Ms. Burman, post of in view of the fact that the matter of grant of approval to strike out the name of the tenants from the subject plot is stated to be pending before the district commissioner stroke additional district commissioner revenue Dhubri, the this court is of the considered view that instead of keeping this writ petition pending, the same can be disposed of with a direction to the district commissioner, additional district commissioner revenue to finalize the matter of grant of striking out the names of the tenants from the subject plot within as expeditiously as possible, within an outer limit of 6 weeks from the date of submission of a certified copy of this order by the petitioner at the office of the respondent number 2. Post of it is further observed that before finalizing before finalizing Respond number 6, it is noticed that the respond number 6 was he was heard or not?
It is perhaps not mentioned in the order, my lord.
The,
Let give him a hearing also, my lord.
huh?
Let give him a hearing before the
It
DC,
is,
my lord.
it is observed that before finalizing the matter of grant, such grant, comma, an opportunity of hearing is to be afforded to the respond number 6. And in such view of the matter, comma, this court finds that there is no necessity to issue notice to the respond number 6 at this stage. Post of it is ordered accordingly.
Speaking order doesn't reflect.
It is ordered accordingly. Post of a copy. That is ordered accordingly. This order disposes of the petition. A copy, the copies of the documents, placed by Ms. Borman are to be kept with the case record by marking it as by marking them collectively as document A.
Obliged.
Obliged.
I see. By the I see. Yes. Online as
Timing method. Item number 2.
Mr. Upaidha, you go through it. You go through it. We'll take up at 2. So that take up at 2. Yes, Mr. Diwan.
Lordship.
At 2.
Lordship.
Item 5.
Yes, madam. Any instruction?
Demarcation was kept in abeyance due to objection raised by the respondents. Short report has come, my lord. Copy. Copy extra 9. Respondent বনাইছে নেকি তেনেকে? কিছু করার ভালো হবে।
Then let notice be issued.
Notice be issued, my lord.
Heard Mr. P.A. Learned Counsel for the petitioner. To Mr. Where is Mr. Aforesaid?
Notice it.
Please. Mr. Aforesaid, A. Aforesaid, Revenue. 1, Miss M. Borman. Learned Junior Government of Assam for the respond number 2, 3, and 4.
2, 3, and 4, my lord.
The petitioner submitted agreed by non-filation of a demarcation proceeding after initiation in the month of December 2025 in respect of a in respect of a plot of land measuring 1 katha and 4.8 lessa, covered by Dag number 367 and KP Patra number 348. Situated at Revenue Village, Puporagao. The petitioner has approached this court seeking inter alia direction to the respond number 2 and 3 to complete the identification and demarcation of the petitioner's said plot of land Post of when Miss Borman, learned junior government advocate, has submitted on the basis of instructions that when the process for identification and demarcation of the petitioner's plot of land was initiated, the respondent number five,
5, 6,
Six,
and
five,
7.
two, and 7. 5, 6, and 7 have submitted an objection to drop the demarcation proceeding on the claim, making a claim that they are in uninterrupted possession of the said land, sought to be demarcated, since many decades. The matter would require consideration. Issue notice returnable on so and so has appeared accepted. Okay, Mr. S. Dotto. Okay, S. Dotto DDO. No formal notice. Extra copies are received upon 5, 6, 7 by speed post within 2 working days.
22nd June. Item 6.
May I please? Also, in this case, the present petitioner is a businessman and he has a small computer shop and he sell.
Okay, heard Mr. M.U. Mahmood, learned counsel for the petitioner. M.U. Ahmed.
M.U. Ahmed.
Miss M. Borman, learned junior government advocate for the respondent number 1 and 3, Mr. M. Sharma, learned standing counsel, Central Bank of India, for the respondent number 2. Full stop. The case of the petitioner is that he maintains a savings,
CC account
as a proprietor of Messrs. CHIP, SHIP solution, maintains a current account number CC within bracket press credit account number 56573900371 at Borpeta Road Branch of the respondent number 2.
Matter pertains to this thing.
Perhaps, my lord, as mentioned in paragraph 3, they have to make the Solapur police station cyber cell Maharashtra main party, my lord. The freezing is on the behest of that department. Here we could have only intimation.
As per instruction of senior police inspector. Okay. The petitioner stated that as per instruction received from senior police inspector, Solapur City Cyber Police Station, Maharashtra, the respondent bank has kept the said CC account of the petitioner in freezed condition. To stop. On inquiry made by the petitioner with the respondent to bank, the petitioner has been informed that there is a, how many transactions? So many. So many.
Three transactions in lot. 3 transactions.
Then
At transaction details.
There are 6.
It has reflected in annexure, your lordship.
Case number 23.
23, your lordship may kindly.
Does not look like there are three number of doubtful suspicious transactions which led to the order of withholding of the bank account. First of para Ms. Borman, Learned Junior Government Advocate, and Mr. Sharma, Learned Standing Counsel for the respondent bank have submitted that the bank account CC account repetition has been kept on with kept freeze as per the instructions received from different authorities, and those authorities have not been made party respondents in the instant writ petition. First of the issue notice returnable on so and so, as so and so appeared accepted. Para. The question of maintainability of the writ petition due to non-implement of necessary party will be considered at an appropriate stage. Extra copies, huh? I can read you.
Items 7 and 8.
Yes, this was tagged.
Yes, it was tagged with my item. The matter has become infructuous in view of an order passed by the circle officer on 11/12/25, Your Lordship, whereby the demarcation that was carried out in respect of demarcation case number 13 of 22 has been disposed of, Your Lordship.
This is part of which order, which repetition?
Lordship, this order may be just please.
Lordship may take up, Lordship, item number 7, Lordship.
Item number 7 is what?
Item number 7, annexure 6, page 20.
Abdul Kadir. Page 20.
Page 20, that was the order passed by the circle officer, Lordship.
What would that is?
Whereby the demarcation of the applicant was rejected.
But it's part of the second petition. More. Please take your seat. Let me read first. Complicated.
It's a bit complicated.
To understand the facts first.
Means Your Lordship, if I may just say, if Your Lordship kindly in item number 8 of mine, there was an order passed by this honorable court because the respondent number, this Talima Garo, the respondent number.
I'll be able to appreciate if I go through it first. Otherwise, it will be very difficult for me. These land matters, I find it very difficult.
Your Lordship, may
just a minute. Just a minute. Let me read, then I'll be able to appreciate your submission.
Lordship, there was an order, means respondent number 4 had filed an application seeking demarcation of a particular.
Respondent number 4 of what? Which one?
Please
tell the name, otherwise it'll be very difficult for me.
Item number 8.
Galima
Garo. She is the common person in both the cases. She had filed an application before the circle officer for seeking demarcation of a particular plot of land. Now, on the earlier occasion, there was an order passed by Your Lordship in annexure 10 at page 66 in item number 8, where on 25/10/24, whereby your lordship will find that
Which order page?
page
Annexure 8.
66, annexure 10,
Page 59.
6489, your
Ah,
lordship.
which one? 6489, yes.
Page 66, your lordship will find.
66,
Yes, annexure 10.
yes.
In this case, your lordship, there was a contempt case initiated by us before your lordship, whereby there was a specific direction by the honorable court to take up two demarcation cases initiated by the same person together. Now, while this was pending, the circle officer has proceeded and disposed of one of them, and that is the order which I have placed before your lordship. But what had happened that the respondent number 4 during the entire proceeding did not turn up in spite of repeated opportunity, though we appeared and filed our respective objections to the application. Thereafter, the circle officer by the order dated 11/12/25 had was pleased to close the proceeding because of non-cooperation of the respondent number 4. So
Okay, we'll apply our mind after some time, let the other cases be there, because it requires some. If, your case is infractuous, then we'll close this. Then if he has any surviving cause of action, we'll
yes, sir.
find out.
Yes.
Right, let's close other business, we'll come back at 3 o'clock.
Item number 9.
Agreed by, Miss, marriage registration. That day, marriage registration was on the seal, no? So? Non-delivery of points. Yes, madam, what has happened in this case?
Both the petitioners are major lordship. They have applied for
What did you do?
marriage registration,
And
but they have been denied the service, lordship.
Submitted online application you should. But madam, you did not, have not appeared. You have not appeared before the court. You have simply submitted the online application. Procedure is different.
No, Lordship, nowadays it is done online only, Lordship.
No, that is not there. The procedure is different. After expiry of 30 days from the date of notice and within 60 days, both the parties will appear before the marriage officer. That is the procedure.
Lordship, they provide a date. After applying the application, they provide a date. But they have not provided anything to us.
No, that
And,
is not the
no,
procedure.
no objection was also made.
That is not the procedure, madam. Where have you stated that you have appeared?
Lordship, after 30 days, they provide a date.
No, no, no. That is not the procedure. Now, what has happened now?
They verbally
24/6. You appear, 60 days are still available.
we have
But-
appeared, Lordship, but they have
No, madam.
denied.
Don't try to say something which is not there in the apartment. Where have you stated?
Synopsis, Lordship, last.
No. Synopsis is not on oath. Come to the main petition. Where have you stated? Not being entered in. How can it be? It is entered in. It has been registered. The application has been registered.
Lordship, at page number 5, Lordship, para 4.
Madam, I have seen it. And responsibly I have made this.
Lordship, kindly after some time, Lordship.
What sometime? No sometime. If you want, you can appear before the marriage officer within 60 days from the date of receipt of application, which will be on 28th June 2026, which is still, the time is still available. Go and appear. Heard, Miss S.R. Major Bhuiyan, learned counsel for the petitioner. Mr. A. Aforesaid.
They are not.
Oh, they are not. And Mr. H. Sharma, learned additional senior government advocate for the respondent number 1 and 2. Post of para. The two petitioners herein have stated that both of them are major and have intended to solemnize their marriage and register it under the provisions of the Special Marriage Act 1954. Post of. The petitioners have stated that for the purpose of intended marriage, the petitioners had earlier submitted an application online on 21/11/2025 as issuance of marriage certificate under the Special Marriage Act has been declared to be a notified public service under the provisions of the Assam Rights to Public Services Act 2012 as amended. Full stop. The said application, the receipt of the said application. So full stop. The application dated 21/11/2025 was acknowledged by acknowledgement number page 16. Full stop. Para, the petitioners have stated that after the application dated 21/11/2025, no date was given for solemnization of their marriage and its registration, though there was no objection from any corner. Full stop. Due to inordinate delay on the part of the registration, on the part of the marriage officer, the registration of the marriage in terms of the first application could not be finalized as the requisite time period had elapsed in the meantime. Full stop. The petitioners have stated that they have again submitted an application online on 28/4/2026. Full stop. The said application was received said application for marriage registration was received by acknowledgement number page 17. Full stop. It is a case of the petitioners that the said application has not been processed by the respondent number 2, the circle officer, Thing Revenue Circle, District Nagaon, on some spacious SPACIOUS ground. Full stop. Para. By an office memorandum under memo number RRG.12/2012/100 capital A dated 12/4/2012 13, comma, the state government in the revenue registration, revenue and disaster management department as outlined has notified the general guidelines regarding the standard procedure to be followed for what is this? For providing service relating to issue of marriage certificate. Post of the contents for ready reference, the contents of the office memorandum are reproduced herein below. Para. From the office memorandum, it is notice that after in case of intended marriage, persons eligible to enter into marriage within bracket, bride and the bridegroom, bracket close, would have to issue notice of intended marriage to the marriage officer with signature of witnesses in the prescribed form in triplicate and deposit necessary fees as applicable, full stop. After expiry of 30 days from the date of notice and within next 60 days, both the parties will appear before the marriage officer for solemnization of their marriage, full stop. The applicants have to submit a declaration under Section 11 of the Special Marriage Act 1954 before the marriage officer with 3 witnesses. Full stop. The marriage officer, after taking declaration from the bride and the bridegroom, would administer an oath by them in presence of 3 witnesses before and issue a certificate with signature of both the parties along with 3 witnesses. Full stop. But the petitioners have stated that what did you submit along with your
Lordship application.
notice, standard format, all these?
Everything online.
If the petitioners have submitted the online application on 28/4/2026, along with all the requisite documents in terms of the office memorandum dated 12/4/2013, as the petitions have contended that they have submitted. And the period of 60 days from 28/4/2026 has not expired till date. The petition, sorry, a period of 30 days are yet to expire. From a period of 30 days from 28/4/2026 is yet to expire, the allegation that
Sorry, Lordship, may I point out, Lordship?
Firstly, Lordship, state has not been made a party here. Secondly, marriage officer is not a party here. So whether this writ petition is maintainable, Lordship? I am holding it to be premature. Lordship, but even then, anyway, this type of, leaving aside all these lacunas, we should not encourage Lordship this type of. But anyway, I'll leave it to your Lordships. কি কলো? A period of 30 days from 28/4/2026 has not yet expired, comma, the writ petition preferred under this writ petition preferred under Article 226 of the Constitution, seeking a direction for extending the service of issuance of marriage certificate is found to be premature. Full stop. Moreover, comma, the marriage officer moreover, neither the state government in the Revenue and Disaster Management Department, nor the marriage officer, nor the jurisdictional marriage officer has been made party respondent in the writ petition. In such view of the matter, the writ petition is also not maintainable for non-implement of necessary parties. So be that as it may, as the period of 30 days has not yet expired, comma, and it is open for the petitioner to appear before the marriage officer before 60 days after expiry of a period of 30 days, comma, it is open for the petitioners to appear before the jurisdictional marriage officer to consider their application, comma, stated to have been submitted on 28/4/2026, comma, and if upon their appearance, the marriage officer finds that the application is complete in all respects and the documents submitted along with it are as per the office memorandum dated 28/4/2013, then the marriage officer shall proceed to consider the application in accordance with law. This order, full stop. It is accordingly held liable. So non-implement as well as premature, but however it is open, you appear before the marriage officer. If your application is correct, along with all the documents, you appear before 30 days, 60 days from 28/4/2026.
12. Item number 12. May please, Your Lordship. Bank account of the petitioner has been.
Pardon, Mr. H.R. Amir, learned counsel for the petitioner. Yes, can you obtain instruction? How much is the dubious instruction?
Your Lordship, only on the basis of the cause list I am appearing
I
after
will
taking
start copy.
instructions. So
Can you get instruction?
yes, Your Lordship.
What is the suspicious transaction?
2,000 rupees, my lord.
Okay. And Mr. M. Sharma, learned counsel for the respondent. Ujjivan Small Finance Bank, post of para. It is the case of the petitioner that a bank account number so and so maintained by him in Lasit Nagar branch of Ujjivan Small Finance Bank has been kept freezed in view of a suspicious transaction dated 7/1/2026 to the extent of rupees 2,000. First of Mr. Sharma, learned counsel appearing for the respondent bank shall obtain instruction as to whether, apart from the said suspicious transaction of rupees 2,000, there is any other suspicious transaction in the said account, and whether the petitioner can be allowed to operate the bank account by keeping the suspicious transacted amount of rupees 2,000 on lien. Mr. Ahmed, learned counsel for the petitioner, shall furnish a copy of the writ petition. 2 copies or one?
One
copies or 1 copy of the writ petition along with annexer to Mr. Sharma during the course of the day to enable Mr. Sharma to obtain the necessary instruction. Release the case next week.
Yes, Your Lord.
Release the case on sales.
2905. Item number 13.
Your Lordship. Well, this petition is basically for remeasurement and re-verification of the acquired land, my lord.
Remeasurement.
Yes, my lord. Page 8, para 6, kindly see, my lord. That is clearly I have stated there.
Para
6, page 8. In the record, it is seen 2 cut at 10 shot, but
will
in fact,
come to knowledge that authorities required more total land measuring.
It's a secretary code.
information दिले बिचारी ना कल पीपी सारे आपको गुड़ी हमें बेसिक देखिए बेसिक अथॉरिटी है
Where is the notification? Notification is annexed.
No, my lord.
Hmm?
No, my lord. I have issued the notice, Annexure 2, 3, my lord.
Hmm?
Annexure 2 and 3 notice they have issued. Thereafter, payment.
No, what is this case? Assam Railway. Oh, what is your total land?
Total
Lot
land.
of land is the owner of various streets.
6 kata 8 chotak, my lord.
Hmm? Your total land is 6 kata 8
8
kata.
chotak. Yes, my lord.
Ownership document. Another no. What is 27/4/2022?
My lord, 2 notice has been issued, my lord.
20. To inform you that where is Annexure A to page Annexure 3? Come to Annexure
Page 3. Yes, my lord.
There is annex and there is Annexure A There is annexure A. This is not land acquisition under the National Highways Act, as it is clear from this annexure. There in annexure A to this notice, the exact amount which are sought to be acquired are mentioned. Is it not? Page 17, second paragraph.
Yes, my lecture one for Gazette notice, so data report of a general schedule the purchase in lecture A.
This is a case of negotiated settlement, not under National Highways Act.
Let it fix another day. Let it take instruction.
Moreover, the pleadings never says that he has got more land than 6 leases. Neither any document to show also, my lord.
Where is your document, sir? Which come to page 14. Rolid Dr. Haji Anamuddin.
Haji Unamuddin.
Which is your area? Please tell me. In the vernacular. Haji Anamuddin is serial number 10.
10.
Yes. Which is your land?
Demarcation.
Which is your land, sir?
He is Anamuddin Barbhuya, son of Basaruddin Barbhuya.
Basiruddin.
My lord, number 10 is shown as Haji
Enamuddin.
Amanuddin.
Enamuddin.
Haji Anamuddin. Basiruddin.
Son of Basiruddin.
Where is your land? Dark number, patta number 224. Patta
224 is.
What is the patta number? Patta number is very vague.
Very, very, yes.
Land. Land is also. Which one is land? Your land. And moreover, the provisions of National Highway Act would not come in.
Yes, my lord, this is not applicable as per this, my lord.
Better you file better application, not this way. Without anything, why will
Yes, my
invest our time? And why will ask them? Otherwise, we don't satisfy. Right? You say that you have RS patta number so and so, DAG number so and so in your application, page 20. But we don't know.
My lord, let me take instruction from the client, and if
No,
required.
file better application. This is not way. We will not.
Then
Then you have mentioned about all these 3A and 3D when there is nothing about 3A and 3D. It is a case of direct settlement. Get proper instruction. If you have a case, file a proper case with proper pleading so that we can issue notice to them that yes, more land than what you are paid for have been acquired.
Yes,
But here with this, nothing, there is nothing, sir.
My apology, my lord.
File, I am giving liberty.
Yes.
Don't bring in NH Act. Yes, Mr. Nayak.
Lordship, this is in terms of 2021 notification of negotiated settlement. So whatever has been paid to him or whatever the amount has been fixed, it was only after, taking his submissions
Agreement.
in consideration only. So
But
now he
He
cannot
may
raise
be
any
a cause
objection.
of grievance, maybe that more land than paid for has been acquired.
More land
Let him file proper instruction and proper details. Otherwise, this is going into a fishing inquiry.
Lordship.
Heard Mr. A.Y. Chaudhary, learned counsel for the petitioner, Mr. P. Nayak.
Lordship, in this
Any
matter, I am
revenue?
appearing for response number 6 only. Lordship.
6, okay. Revenue?
RP Talukdar for respondent number 3.
Okay. Revenue A authorized.
Yes, madam.
Who is for 1? Okay, Mr. G. Pegu. Land Central Government Council for the respondent number 1. Mr. A. Aforesaid, Land Standing Council Revenue Department for the respondent number 2. Miss
B. Nandini, appearing on behalf of R.K. Talukder.
R.K. Talukder, Standing Council NHIDCL for the respondent number 3.
4 and
Mr. Das and Das, Land
4 and
Revenue
5.
Government Advocate for the respondent number 4 and 5, and Mr. P. Nayak, Land Standing Council PW for the respondent number 6. Who's after making submission. At some length, Mr. Chodri, and Council Board of Petition has submitted that the petition may be permitted to withdraw this writ petition to file it afresh with better particulars.
Yes, ma'am.
So the said submission of Mr. Chodri is not opposed by the Learning Council for the appearing for the respondents. In view of the above, the petition is allowed or is dismissed on withdrawal with liberty to file it afresh with better particulars.
Item 14. May I please, Your Lordship. My lord, the petitioners, the respondent were constructing a RCC bridge over the petitioner's Patalian lordship. But without any following any due procedure of acquisition or without making any compensation thereof, lordship.
What is your exact case? Some amount is paid.
No,
Some amount is paid.
Not yet paid, lordship. They have requested us to pay
Earmarked.
lordship.
But what is your case? Let me see for the owner of some plot. Yes. We issue notice.
Hello.
Nothing has been paid.
They have calculated something. I not forgot.
Heard Mr. M.I. Hussain, Learned Council Board of Petitioners.
It was
Mr. A. Which for Public Works? Public Works. You are mute, madam. You are mute. Number?
My lord, if your lordship come for time being, my lord, page 55. My lord, it says prayer for enhancement of award amount in award number 3. Enhancement, my lord, how come
Enhancement?
petition will come?
enhancement also there.
If there enhancement, my lord, reference case will go, my lord.
Apart from lordship, that a DAG number also has not been taken into consideration, lordship. And without following any procedure.
Let me see first, then your prayer. In notices for Mediation. Award number 2 and award number 3.
Yes, lordship.
Where is that?
Award number 2, award number 3. Lordship, may kindly find at page 50. 50 and page 50 and 52.
This is to one Abu Bakr.
This is Abu Bakr.
Yes, this is.
Who is Abu Bakr?
Abu Bakr is the father of the petitioner, lordship.
Okay. And there are 2 awards.
There are
award number 2 and 3.
Yes, lordship.
By what kind of grievance?
They have also not taken into consider another plot of land by DAG number 141. They have taken into consideration the land by DAG number 215 and 216. 141 they have not taken into consideration.
Okay, 141.
Yes, lordship.
these two, if you are agree by these two award,
Lordship.
this is not the forum.
Not only these two, Lordship.
Oh, wait, sir.
Lordship.
You say you have 3 pieces of land,
Lordship.
right? 3. Is it not?
Yes, Lordship.
Now, one is DAG number 216. One is DAG number 215.
Yes, Lordship.
And another is
141.
141.
Lordship.
So your grievance is that for 151, nothing has been paid, but it has been taken over or acquired without paying anything, without following any due procedure of law.
Yes.
That is what your case.
Yes.
Now, why you have included this award 2 and award number 3? If you are aggrieved by the amount of compensation herein, if you're, according to your estimation, the market value of the land is much more than what you have been paid for, this is not a forum. Why you have clubbed all the...
So we have...
so why you are making everything complex?
Lordship, therefore, we have filed the page 55, Lordship. This application before the collector, Lordship.
That is a different... why you are clubbing everything for creating difficulties for the court? Are you not aware? If you have made some application for enhancement
Lordship.
of award number 2 and 3,
yes,
before the Deputy Commissioner or competent authority land acquisition Kala, and he is sitting over it, that is a different cause of action, sir. And so far as DAG number 141 is concerned, that your land have been taken over and no compensation is paid, that is a different issue. Why you have created all these difficulties? For that, there is a different direction to send it to the arbitrator for enhancement.
Yes, Lordship.
But this is multiple cause of action in the same writ petition. This is
Both players are there, Lordship.
how can it be then? This is not possible. Your DAG number 141 has been taken over by the authorities, but without no payment has been made. That is a different cause of action. But where the award has been made, but you are not satisfied with the award.
Yes,
that is a different cause of action. Have you understood? But you have clubbed everything for the court, and court will look into it and spend time for that. It should have been two writ petitions. One for award number 2 and 3. We'll dispose of the writ petition. You could have disposed of to take directing the arbitrator to decide the matter.
And Lordship, can it be considered for the compensation already awarded, Lordship?
No, my lord, is this
For the other part, we would file
page
separate
56, that I therefore request for myself and behalf of my siblings, request your good self to please enhance the LA award amount in award number 3 and LA case 2, award number 2, and how come, my lord, this under 226, my lord?
It is the duty of the council also to reduce the difficulty of the courthouse.
Sorry, Lordship.
As an officer of the court, you jumble up everything just for your benefit and multiple causes of action.
Lordship, may kindly consider this application for enhancement, and I will file separate application for the
Enhancement, how
plot
come under
not
226?
considered.
No. This enhancement is to be considered by the arbitrator.
Yes.
Mr. Hussain, you are a seasoned counsel. You should have known it. If your enhancement is for award number 2 and 3, and Kala is sitting over the matter, where is your application for enhancement?
My lord, this is page 55.
Page 55, Lordship.
You make this application to the
Additional
competent authority Kala, that is additional deputy.
That is there, Lordship, in the provision. Lordship, a provision also is there that they has to send it to within 30 days after.
Deputy Commissioner is not the authority here. Who has decided? Let us see the notice.
Collector, Lordship.
You jumble up everything and
Yes, Lordship. Notice is
try to
Lordship.
Procedural Zilla Ayukta
44.
and let acquisition officer. You did not submit the application before the additional deputy commissioner. You have filed it before deputy commissioner, and you want this to be decided by the court. There is not a way. You still have time. You are still having it.
My humble understanding, Lordship, the ADC is under DC, therefore.
Then I am dismissing it. I am, if you are not.
Lordship, I have got the point your Lordship has suggested.
Multiple causes of action in same writ petition is not going to entertain.
Then Lordship may kindly consider for enhancement.
Not entertaining then. Mister, I have given you indication. If you have any grievance regarding award number 2 and 3, file an application before the
That I'll do.
additional deputy commissioner, who is the land acquisition officer. Then if he sits over the matter and does not send it to the arbitrator, you come here, we'll direct.
I'm agree.
Right. So far as this other DAG number is concerned, right, we can entertain, consider. I'm not saying that I'll not consider. But question is, you have to, distinct cause of action should be treated separately. How you can...
I got it.
We'll keep this pending regarding your dissatisfaction about award number 2 and 3 for next 3 years. For next 3 years, until we decide.
Nothing.
Have you understood? Thereafter, we can hold that, oh, this is not an application before the appropriate authority.
Yes.
I am trying to actually benefit you, but you are not understanding it.
I have understood.
Take your instruction. If you do, otherwise, I am giving you liberty to file this in separate way. Regarding 141, you file it differently. And regarding award number 2 and 3, you file it differently. Right? File that about 141 at the earliest, but so far award number 2 and 3, how much is the time?
Time, my lord, 41 days.
No, let us see.
60.
This is under what?
60.
This is under
right to fair compensation and
right to fair compensation. And the amount has not been released.
Not released.
Reference, my lord.
You have time. What did you do after that?
6 weeks.
Within 6 weeks.
Section 6.
Paragraph?
Section 64, my lord.
64 2B.
64.
64, my lord. My lord, one more provision also there, provided that collector may enter an application after the expiry of said period within a further period of 1 year, if he is satisfied that there is sufficient cost for not filing within the period prescribed in the first provision.
Anybody interested who has not accepted my written to the collection, you get a million. No, this period comes from when?
My lord, from the date of the award, my lord. Because it's now his prayer is to set aside the impugn notices also. If the impugn notices goes, my lord, everything goes. If a lordship comes to page 14, the prayer section, my lord, it says, while writ of person.
Setting aside the impugn notices for land acquisition and notices dated so asking.
Now the impugn notices says that it is hereby informed the patta land in your name has been acquired for construction. And now he comes and says he needs an enhancement.
Read of manner be issued directly in the government to provide education for the market period so and so, so and so. Land measuring so and so.
For these two award, I think it will better for him to file an application under 64. Possession, according to him, which has been taken over, nothing has been paid. That he
possession has been taken over.
No, what he has submitted, my lord. For that, my lord, separated writ can lie. He can withdraw this, my lord. Otherwise, there is it will be difficult for part of me also to get the instruction, my lord. In a proper way, man.
Now come to 77.
77, my lord.
Section 77.
Yes, my lord. The amendment going to deposition on the making an award under section 38. No, no. This is not case, my lord. His case is just he has been aggrieved by the award, my lord. He need an enhancement, my lord. For enhancement, my lord, section 64 application will have to be there.
No, I'm on the point.
My lord.
Just making an award.
My lord.
A land acquisition officer
My lord.
is not discharged of his liability.
Yes, yes. That's true, my lord.
Right.
Right, my lord.
You have to be
Yes, yes.
that he has to pay it to them by depositing the amount in their bank account.
No, my lord.
Right.
Right, my lord. But his
Unless, no, wait, Mr. Das, unless he completes the award procedure, just making an award and keeping it pending for disbursement for next 5 years.
Yes, yes, yes.
Whether he has completed his obligation?
Yes.
No, absolutely not. 77 subsection.
No, my lord. It says, my lord, page 56 for time being, my lord.
But here it,
Two, my lord. Two.
I have understood this is made before district commissioner. And here it is. Okay, collector. This will do.
My lord, just para 2, I just want to read once, my lord. It says, my lord, that during the acquisition of land for construction of the RCC, page 56, my lord. It's their pleadings, it's their representations. It says in this way, my lord, that during the acquisition of the land for construction of the RCC bridge number 5/1 on Full Katari to Bondihana, the allotee was pleased to sanction the land amounting to this for land measuring 3 kotha and this for legitimate 2 kotha. My lord, but the land compensation amount are not satisfactory as the said compensation has been calculated without considering the solicium, zeroed value and market value. Well, for this enhancement is needed. Then therefore I request for myself and my behalf to enhance the award. For that, my lord, this perhaps my understanding says, my lord, 226 does not lie, my lord.
64, no.
Yes.
But if he sits over the matter, the collector,
Yes.
after this application,
Yes.
sits over the matter,
Then, my lord.
definitely, read will lie.
Yes. Yes. Then it will lie. But
It is collector.
No, my lord. He never says. He says it is therefore your request honor to make a proper calculation of consideration. He can file a proper application before the ADC, my lord.
Sir, no. It is not a case of Kala. It is a case of collector. The word section 64 and 77, it is collector.
Collector is a district commissioner.
So it is correctly made. Then if he receives such an application, where the applicant says that the award is not satisfactory, right? But he knows that he has already passed an award.
Yes.
In that case, it is his duty to send it, refer it to the authority.
Yes, my lord.
Right.
I'm not disputing that, my lord.
Right.
Yes.
Because they are saying that their amount is not satisfactory. He should immediately forward it to the reference authority.
Yes, my lord. With that,
under section 64.
Yes, ma'am.
Right.
Yes, ma'am.
And so far as this is not part of DAG number 141. So he has clubbed all the issues here in one writ petition. And for that, it is difficult. And if I dispose of by directing the deputy commissioner to take this application and refer it,
Yes, ma'am.
then with that, the other issue is not decided, it will be constructive res judicata again.
My lord, with other issue, 1 minute. And my lord, he can file that an order may be passed to the effect, then he can find a separate writ for that. Then, my lord, otherwise my instruction will also be difficult to get a proper instruction. Again, he will be sufferer, my lord.
No, that will be again difficult for the court, and sometime it will be interpreted in a different manner, and it will come again before other court advance again. It will be difficult. Then it will be for his difficulty.
Lordship, for 141, my humble submission, for 141, observation may be made that I will file separate application, and this petition may be considered for the compensation part, Lordship.
Oh, 141, then can file a separate application.
Yes. That of the.
And this may be, this representation may be taken as an application under 64 and may be report to the authority, my lord.
See the prayer.
Exactly, my lord.
So this is difficult for.
I understand. He's asking for quashing of the notices.
This is difficult. We'll come back at two. Victory. We're not entertaining this petition. Multiple causes of action.
Lordship, I may be allowed to file a fresh petition.
Mr. M.A.I. Hussain, Learning Counsel for the
MI.
petitioner, has submitted that as there are multiple causes of action in district petition, he may be allowed to withdraw district petition to file separate petitions with regard to the distinct cause of action. Mr. Wader, revenue. Who is there for the revenue?
Malak.
Please come online. You bought a side revenue. Oh, two, Mr. Sam Borman. 4 and 5. And 8 are present. In view of the above submission made by Mr. Hussain, Learning Counsel for the petition, the petition is allowed to be withdrawn with the liberty as sought for.
There is item 15.
My pleasure, Your Lordship. Lordship, facts in a narrow compass is that, Lordship, a petitioner herein deals in a business of selling and purchasing of vehicle, Lordship. And by Annexure 1, Lordship, he has purchased the vehicle, ultra vehicle from 140 Grasbongsi, Lordship, by Annexure 1. And subsequently, that vehicle was sold out to the respondent number 10, Lordship, by Annexure 3, Lordship, by executing an agreement before the Notary Public, Rongya, Lordship.
Respondent number
10. Rajendra Soni, Lordship. So subsequently, Lordship, what happened that it was alleged that, Lordship, that vehicle was seized by Nalbari Police, Lordship. Some dues were pending by the earlier owner, Lordship. So subsequently, the petitioner was summoned by the Crime Branch Police Station, Lordship, on 25, Lordship, 10/2025. And on his appearance, he was directed to refund back the amount, consideration amount of rupees 10 lakhs, Lordship, by the Crime Branch Police official. And subsequently, he was also asked to execute an agreement that he would pay the consideration amount of rupees 10 lakh to the respondent number 10.
Yeah.
So since police was repeatedly calling, Lordship, this petitioner filed an anticipatory bail application before this honorable court, Lordship. That is, Lordship, AB 2792, Lordship. Lordship, by Annexure 4, Lordship, this honorable court was pleased to direct the public prosecutor, Lordship, to obtain instruction whether there is any case against the petitioner, Lordship. And the method the case was further posted on, Lordship, 1/12/2025, Lordship. And during deliberation of the anticipatory bail application, Lordship, the learned APP has submitted on instruction that, Lordship, no case was registered against the present petitioner, Lordship. Lordship will find that order Annexure 5, Lordship, page 34. And this honorable court, considering entirety of the matter, Lordship, close the petition anticipatory bail application, Lordship. However, giving liberty to the petitioner to avail the appropriate remedy under the provisions of law, Lordship. So, Lordship, subsequently, the respondent number 2 has threatened the petitioner that he have to face dire consequences as he was going to lose case against him in his native state, that is Rajasthan Lordship. So such threatening was not persuaded, Lordship petitioner was not persuaded by such threatening because nothing was happened in Rajasthan Lordship. The petitioner never went to Rajasthan Lordship for the purpose of selling and purchasing of vehicle Lordship. Entire transaction was performed within the state of Assam Lordship, within the jurisdiction of the Honorable Court Lordship. So, nevertheless, Lordship, on 16/5 Lordship, the petitioner received a communication, Lordship, a notice issued under Section 35 Lordship by the Jothwara Police Station, Lordship, Rajasthan, asking him to appear, Lordship, within 2 days, Lordship. That was sent, Lordship, electronically in WhatsApp, Lordship. So, agreed by that notice, Lordship, I am before your Lordship, Lordship.
WhatsApp communication is illegal, but here the cause of action has not arisen here. No cause of action.
Lordship.
No cause of action here.
And that transaction here, Lordship. And
that is not to be decided in a writ petition.
Lordship, because no alternative remedy, Lordship.
You have a remedy.
Because by
if you sit tight in Assam, it is up to you. But though it is illegal, sending of WhatsApp notices by
Lordship, whether that can
someone under Section 35(3), but this is shows law.
Lordship, kindly have a look, Lordship. I have ever, Lordship. This Honorable Court, Lordship, in a criminal petition in the Itanagar Permanent Base, Lordship. Kindly have a look, Lordship, para 11. I have extracted, Lordship, the relevant part.
That, sir, I have said already, which is not to be repeated, that a notice sent someone under Section 35(3) BNSS by WhatsApp is illegal. Right? But that matter, wherefrom the notice was sent?
Kindly have a look, Lordship.
In Itanagar police station.
And in that case, Lordship.
Yes, please tell me.
That was within the state of Unauthorized, Lordship. But, Lordship, whether under Article 226, subsection 2, Lordship, this Honorable Court can interfere in this matter or not is no more as integral, Lordship. My side the authority, Lordship.
Nobin Chandra Majid here.
Lordship.
You will cite Nobin Chandra Majid here.
No, Lordship. One judgment by authored by Honorable Justice Ujjwal Bhai, Lordship.
Party number 2.
Party number 2. And another by division bench, Lordship.
Family court is someone domestic violence.
But judgment authored by my Lord Justice Ujjwal Bhai, Lordship. Para 21-22, Lordship, relevant. So may kindly look para 21, 22, 26, 27, and 28.
How division bench is related?
Lordship, regarding transfer of cases from Itanagar permanent bench, Lordship, to this honorable principal bench, Lordship. And in the
Sir, that is a different thing. That is one high court having different benches. Right? One high court having different benches. Prior to that, that has been decided. Right? One bench can transfer it to another. This is not relevant to the purpose of the case in Lordship.
My lordship is very much correct, my lord. If a lordship comes to page 12, below 1, my lord. The query made by my lordship, my lord. In the same case, the Honorable Supreme Court in para number 3 has clearly held that service of notice through WhatsApp or other mode of electrical communication cannot be considered or recognized as an alternative or substitute mode of service recognized, prescribed under the BNS in case notice under section 35(3) of the BNS.
That I have already told him.
Yes, madam.
Question is about the cause of action.
Cause of action.
To entertain this writ petition, having the jurisdiction to entertain this writ petition. So far as I have said clearly that sending notice under sections 35(3) by WhatsApp is illegal. That is not a permitted mode.
Yes.
Lordship may take a cue from the judgment authored by my lord, that is Ujjwal Fair, Lordship, para 21-22, Lordship.
But to the extent there are opposite views of the Supreme Court, we'll issue notice at this stage. Heard. Because this court has already held that this kind of notice, similar type, that you have to take recourse before the appropriate court forum. So when this court has already held, we have to decide it accordingly. Heard. And on the basis of Supreme Court decisions,
Yes.
Mr. G.R.M. Mobarak, learned counsel for the petitioner, Mr. N. Das, learned junior government advocate, Assam
1, 2, 3, 4.
1, 2, 3, and 4. First up, issue the petitioner has assailed a notice dated 16/5/2026 issued to him by the respondent number 9 under section 35(3) of the Bharatiya Nagorik Suraksha Sanhita 2023 in connection with Jotwara, Jaipur, West Bengal Police Station case number 296/2026, which has been registered under sections 318 (4) stroke 316 (2) stroke 351 (2) Bharatiya Nyaya Sanhita 2023. First of the ground of challenge is that the impure notice has been sent to the petitioner only by WhatsApp, which is not a permissible mode to send such notice in view of the decisions of the Honorable Supreme Court in Satendra Kumar Antil versus Sweds, reported in Sweds. The learned counsel for the petition has also asked that in view of Article 226 (2) of the Constitution of India, this court will have jurisdiction to entertain the petition. The matter would require consideration, issue notice returnable and so and so as 1 to 4 by Das, no formal notice. The Architect Churi, Deputy Solicitor General of India, respond number 5, copy the following to work in this. Steps 6 to 10 by speed post within 2 working days.
Extra copies.
Yes. Extra.
Till then, no coercive action, Lordship. Proceed.
No.
22nd June.
I'll put a question. On the next that you answer it. For quashing of the proceeding of that particular case, which is the forum?
Absolutely 528, Lordship. Because
528, which is the forum? Show us with authority. If this court can derive jurisdiction, definitely this court will have jurisdiction to entertain this said petition.
because Lordship, my humble submission,
Just show us.
my point one line, Lordship. With your Lordship interest, my submission.
Not required. Show us on the next step.
Time being matter. Item 2.
2025 INSC 909.
May it please your lordship.
Heard Mr. A. Diwan. Learned counsel for the petitioner. Revenue, please tell me.
Yes, my lord. Yes, my lord.
Aforesaid. Standing counsel Revenue Department for the respondent number 1.
2 I am appearing.
Miss M. Bormon, learned junior government advocate. Assam for the respondent number 2.
3 and 4 I am appearing.
And 2 and 5. And Mr. N. Upaidhyay, learned standing counsel Litigation Department for the respondent number
3 and 4.
Post of para. The petitioner invoking the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India. The petition has referred, and this the instant writ petition, to assail an eviction notice dated 12/2/2026, issued by the respondent number
Respondent number 4, lordship.
Respondent number 4, post of para, by the impugned notice dated 12/2/2026, comma, which has been addressed to the husband of the petitioner, comma, son of late Abdul Karim Borbia, ex-SA, comma, the noticee has been informed that he is occupying a government as a quarter, government quarter, comma, government quarter number 2 at Irrigation Colony, comma, Devosthan. Full stop. By serving the notice, comma, the noticee has been asked to vacate the said government quarter within a period of 1 month from the date of issuance of the said notice, or otherwise action would be taken as per government rules. Full stop. The notice dated 12/2/2026 is in continuation of an office letter number, previous office letter dated 2011/2021, post of para. The petitioner, the version projected by the petitioner in this writ petition is that the petitioner's father-in-law comma, Abdul Karim Borbia was an employee in the establishment of the executive engineer, irrigation department, हो जाए, full stop. During his service period, Abdul Karim Borvia used to reside in the said government quarter number 2 at Irrigation Colony, Devasthan. Full stop. The said government quarter number 2 is situated in a plot of land measuring 3 kathas and 5 lasas of government land. Full stop. Abdul Karim Borvia retired from service on reaching the reaching superannuation on 31/7/2014. In support of his date of retirement, the petitioner has annexed a copy of the pension payment order
Page 19, Lord.
First of para. Abdul Karim Borvia had when did he die?
2/4/2018, Lord.
Where have you stated?
Lordship, at the time of filing of the writ petition, Lordship, that information.
Okay, Mr. Zaman, learned counsel for the petitioner, has submitted that Abdul Karim Borvia expired on
2/4/2018, Lordship.
2/4/2018. Full stop. Para. It is the case of the petitioner that Abdul Karim Borvia and his family members, consisting of consisting of the petitioner's husband, Mohammad Johirul Haq Borvia, and the petitioner has been residing in government quarter number 2 for a long period of 40-45 years without any obstruction from any corner. Close stop. The petitioner has stated that by the earlier notice dated 2011-2021, the petition was asked to vacate government quarter number so and so within a period of 1 month from the date of service of the notice. Full stop. The petitioner has further stated that her husband, Johirul Haq Borvia, lives in Saudi Arabia
Since 2014.
Since
2014, Your Lordship.
2014
Lordship.
for gain. Full stop. For gainful employment. Full stop. Para with such factual projection, the petitioner assailing the impugned notice dated 12/2/2026 has sought for a direction to the state respondents not to act further upon the impugned eviction notice dated 12/2/2026. The petitioners further stated that the petitioner has already submitted an application on 5/1/2023 seeking settlement of the government land measuring 3 kathas and 5 lessers, wherein government quarter number so and so is situated. Full stop. Is located. Full stop. So, it could go. Para. Some public premises. Public premises, right? Admittedly, comma. No, as per Section 2D of the Assam Public Premises within bracket Eviction of Unauthorized Act. Unauthorized Occupants within bracket close Act 1971. Is an enactment to provide an effective machinery for eviction of persons in unauthorized occupation of public premises and certain incidental matters connected therewith. Full stop. Section 2D and Section 2C have provided for the definitions of premises and public premises respectively. Full stop. Para. As per Section 2D, premises means so and so. And full stop. As per Section 2C, public premises means so and so. Full stop. Unauthorized occupation, comma, as per Section 2H of the Act, comma, in relation to any public premises means the occupation by any person of the public premises without authority for such occupation, comma, and includes the continuance in occupation, comma, by any person of the public premises, comma, after the authority under which he was allowed to occupy the premises has expired or has been determined for any reason whatsoever. Full stop. Para. It has been held by the Honorable Supreme Court of India in Union of India versus Onkarnath Dhar, 2021-19 SSC 163, that a government accommodation is only meant for in-service employees and not for retirees or those who have demitted office. Full stop. A government accommodation cannot be allotted to a person who had demitted office. Full stop. A right to shelter is a fundamental right, comma, that may not be disputed, comma, but such a right of shelter is granted to millions of Indians who do not have shelter. Full stop. A section of society, comma, more so retired government employees, comma, who had earned pension, comma, drawn retirement benefits, cannot be said to be in such condition, comma, where the government should provide government accommodation for an unlimited period. Full stop. There is no indivisible. The government accommodation is meant for the serving government employees to facilitate the discharge of their duties. Full stop. The government accommodation is not meant for the retirees. Full stop. The accommodation to the retirees cannot be at the cost of the serving officers. Full stop. For the facts presented in the writ petition, comma, it is admittedly, comma, Abdul Karim Barhuya, who was allotted government quarter number so-and-so, retired from service on 31/7/2014. So thereafter, comma, he expired on so-and-so. Full stop. The family of Abdul Barhuya cannot claim any kind of right for occupation of government quarter number so-and-so after 31/7/2014. Full stop. The petitioner, of the family of the petitioner, has no right to seek settlement of any land on the on and from 31/7/2014, comma, the occupation of government quarter number so-and-so by the family members of late Abdul Karim Barhuya is clearly unauthorized occupation. First stop. The family of the Abdul Karim Barhuya or his son, who is living, who has been living in Saudi Arabia since 2014 with gainful employment, and for that matter, his wife, that is the petitioner, cannot have any right to claim settlement of any government plot of the government plot of land wherein government quarter number so-and-so is located. First of having found no right, having found that no right of any kind has been infringed by either by the impugn notices dated 2011-2021 and dated 12/2/2026, comma, this writ petition lacks merit and is liable to be dismissed. So it is accordingly dismissed. With cost? With cost of rupees 5,000.
Yes, sir.
Which is to be deposited before the registry of this court within a period of 2 weeks from today.
Lordship, obliged, Lordship.
Item 16.
Depublished, Lordship.
May it please, Lord. My lord, both the petitioners, they are recorded owners of a joint partner, my lord. Now,
What you are challenging?
my lord, your lordship will find the ex parte order was passed and the show cause notice was never
Page
served.
63,
Yes,
62.
your lordship may
Hmm.
come to page, this is, my lord, the appellate order.
Yes.
Before that, can I take your lordships to the order?
Right now, I'm dismissing it.
My lord,
No further
Nandini,
submission.
Lordship, Nandini, Lordship.
No further submission.
your lordship kindly.
This is not maintainable at all. A writ petition under 2226 is not maintainable against an appellate order under Section 9 of the Public Premises Act 1971. Only a petition under 227 could be maintainable.
My lord, then I can be given a liberty.
Definitely,
Yes.
but not. I thought that it would be
My lord,
answering the question.
It's all right. In that case, my lord, I may be given a liberty.
Heard Mr. S. Dr. Learned Senior Counsel, stated by Ms. Learned Counsel for the petitioner and Mr. K. Gogoi, Learned Central Government Counsel for the respondent number.
All right.
For all the respondents, first of para. This writ petition under Article 226 of the Constitution is preferred to assail an order,
62.
a judgment and order dated 7/4/2026 passed by the Court of Learned District Judge Kamrup Metro Gauhati in Miss Appeal case number 14/2025. Post of the said appeal was preferred under Section 9 of the Public Premises within bracket Eviction of Unauthorized Occupants bracket close Act, 1971. Full stop. By the judgment and order, by the judgment dated 7/4/2000, in the judgment, in the appeal, the petitioner as the appellant had challenged an order dated 31/7/2025 passed by the estate officer in connection with eviction case number, page 63, keep line order, whereby the petitioner, thus appellant, was directed to vacate the premises in question within 15 days from the date of receipt of the said order. Post of para. The three-judge bench of the Honorable Supreme Court of India in Life Insurance Corporation of India versus Nandini Desai and others, 2018, 15 SSC 356, para 58.
Lordship, para 34, 39 and 59, Lordship. 34, 35.
35.
35, 39 and 59, Lordship.
Not required.
Lordship, Lordship. 59, 59, Lordship.
Has held that
When we have 24 judgment, it is very specific, Lordship. 24 judgment, Lordship.
Justice by Justice Honorable Dipankar Dutta.
Lordship, Lordship, very specific. Paragraph 15, Lordship.
No, it is very specific, very specific.
Lordship, very specific, Lordship. Even Dipankar Dutta's judgment, Lordship, that was paragraph.
The appellate officer, while exercising power under Section 9 of the 1971 Act, does not act as a persona designator, but in his capacity as a pre-existing judicial authority in the district, within bracket being a district judge or judicial officer possessing essential qualification designated by the district judge. Post of being a part of the district judiciary, the judge acts as a court, and the order passed by him will be an order of the subordinate court against which remedy under Section 227 of the Constitution of India can be availed on the matters delineated for the exercise of such jurisdiction. Post of. It has been further held that an order passed under Section 9 of the 1971 Act as an appellate officer can be challenged only under Article 227 of the Constitution of India and not under Article 226 of the Constitution of India. Post of. The judgment in Nandini Jesa has been appropriately referred to in Municipal Corporation of Greater Mumbai and others versus BPEC, Gauhati, etc. 2024, SCC Online, SC 3722, post of. As the repetition is not found maintainable, it is dismissed, with the liberty, reserving the liberty to the petitioner to avail appropriate remedy if so advised.
Obliged, Lordship.
Item 17.
Where is the first show cause notice?
Page 19, my lord. It by Central GST, my lord. It covers
It
covers 7 financial years.
Notice to show cause under Section 74(1).
My lord.
Where is the last part?
Page 45, my lord.
Yes, then what is the order?
Page 46, my lord.
Page 46. Page 46. When it was passed?
It was passed on 24 January 2025, my lord.
You did not appear.
My lord, no, my lord. In this matter, my lord, we appeared. We have submitted our reply, my lord. They did not consider.
In the order, para 49, paragraph 4, no response has been received from the noticee, even after repeated persuasion and issuance of.
We have put this order already in under challenge, man, because we reply was. Sorry.
Page 48. A letter dated 28/6/2021 was issued to the noticee. In reply, you replied,
My lord.
submitted documents. Again asked, someone was issued to the director, asking, so the director appeared. Statement recorded. So you participated.
Yes, my lord.
Then after notice again, you did not reply. Then 3 notices, no personal appearance. Then it was confirmed.
Confirm, my lord.
Where is the operative part?
My lord.
Okay, this is typed copy.
Type copy, my lord.
Page 76.
My lord.
Okay. Then?
My lord, this order pertains to 7 financial year, my lord.
2017 to, I have seen 2017.
Yes, the authority, my lord.
2000, but this is on, that was under section 74.
My lord, 74.
74,
my lord.
Section, where is that? Notice to foreclose. Ah, 2017, 18 to 2023, 2024.
My lord. Now, my lord, on same subject matter, state GST also issued a separate so-called that your lordship will find it page 78. Here, my lord, for the it pertains to financial year 21-22, my lord. So, lordship will see, my lord. There are three matters have been, my lord, here dealt with, my lord. Regarding first is, my lord, mismatch liability declaration of GSTR 1 and 3G9. Then, my lord.
Did you respond?
No, could not respond, my lord.
Did you? You have not responded. But then thereafter,
the order was passed, my lord.
Order was passed.
My lord. Page 89, my lord.
Page 89.
Page 89.
19/12/2025. Is it correct?
My lord.
So you said over the matter.
My lord, whatever this proceeding, subsequent proceeding is barred by section 6, subsection 2B, my lord.
Right, but when opportunity came calling,
my lord,
did you respond?
I could not respond, my lord. Response could not respond.
You did not respond. Then order came calling at your doorstep. Did you respond within the appellate period?
It was passed on 19/12, my lord. If petition was filed, my lord, on 24/4/2026, my lord.
This was issued on 25/9/2025.
25 December.
So you said over the matter.
My lord.
After facing liability under section 74.
My lord.
Right?
Section 74, we have put challenge. That already put to challenge, my lord. First order by the central GST authority has put to challenge, my lord.
Now, after this
subsequent proceeding, my lord.
This 19/12/2025.
My lord.
Have you challenged?
I am challenging here, my lord.
When?
On the count of jurisdiction, my lord.
On account of what jurisdiction?
Because,
after appellate period is over, court cannot condone the delay. Whatever challenge is there.
No, my lord, I am not paying condonation of delay, my lord.
What is the time period for preparing an appeal?
4 months plus 1 month, my lord. 3 months plus 1 month, my lord. My lord, 3 months plus 1 month is the time, my lord. I have given a statement why there was delay, my lord.
Go and explain all this before the appellate forum. This is an appealable order.
But, my lord, if it is...
You did not respond. Cancellation or registration is a different matter altogether.
My lord.
Here, your conduct. First one, I have indicated to you.
First,
3 summons, silence.
First one.
Personal appearance, repeated silence. Final order passed. Where did you challenge it? High Court.
High Court. The reason is that, my lord, I am coming. In the first proceeding, my lord, some reply was submitted in the portal as well as hard copy was sent, my lord. It was not considered, my lord. They presumed there is no reply, but reply was submitted in the portal, my lord. If Lordship permit, I can bring by way of additional affidavit, my lord. First proceeding was put to, my reply was duly submitted.
This notice was served upon you or not?
Is-
Second notice,
It was in the-
25/9/2025.
Yes, my lord. It was actually
Let
in
us
the-
see.
My lord. It was in the portal, my lord. It was served. I'm not denying it, my lord.
Then,
First proceeding, my lord, because otherwise Lordship will say I will be text twice, my lord, for same transaction, my lord. Because, my lord, first notice, my lord, with the central GST authorities, my lord.
lack of jurisdiction, jurisdictional error, but question is that this is an appealable order.
My lord.
This order is an appealable order.
My lord.
I have indicated to you earlier.
My lord.
Right. When an appeal
My lord.
is maintainable
My lord.
and there is a definite period of limitation,
My lord.
then a writ petition can be entertained on the grounds of a whirlpool.
My lord.
But when the appellate period is over,
My lord.
Supreme Court has said,
Lordship, just for a moment, if I
even under Article 142, we cannot condone the delay. Had it been, and therefore that has been clarified, if you are pursuing a valid bona fide proceeding with due diligence in another forum, yes, that can be considered. But whether this can be considered? Yes, Mr. Gogoi.
My lord,
Right or wrong, that is a different issue.
yes, my lord, I bow to your lordship, my lord. In fact, my lord, this writ petition is not maintainable, as because, my lord, the petitioner ought to have taken the, my lord, statutory remedy. First of all.
Yes, that is
Secondly,
what.
my lord, yes. Secondly, my lord, the plea taken in the present writ petition is that it is in violation of section 6(2)(b). 6(2)(b) speaks about, my lord, initiation of proceeding, parallel proceeding, my lord. Here, my lord, the first proceeding was over, my lord, in January 2025, and that too under 74. This is a proceeding initiated under the state GST in 2026 or 25 in September.
6(1)(b).
Yes,
no 6(2)(b), my lord.
2B, my lord. There will have to be parallel proceeding at the same time.
Subject to the conditions specified in a notification issued under subsection 1, where a proper
6(2)(b).
officer
Where a proper officer under State Goods and Service Tax Act or the Union Territory Goods and Service Act has initiated any proceeding on a subject matter, no proceeding shall be initiated by the proper officer under this act on the same subject matter, and it will have to be by the same officer at the same time. Lordship will see proper officer. He has if he initiates a proceeding, he cannot initiate another proceeding on the same subject matter. Proper officer here means, my lord, it is the state GST officers. It's a 2A. My lord, 6(1). My lord, 6(1). Without prejudice to the provisions of this act, the officers appointed under the State Goods and Services Act or the Union Territory Goods and Services Act are authorized to be proper officers for the purpose of this act, subject to such condition as the state government on the recommendation of the council by notification specific.
What do you say about that? You have initiated a proceeding,
my lord,
for the financial year,
my lord,
2021-2022.
Lordship.
Right.
My lord.
And if you come to page 35.
My lord. Yes, ma'am.
Already that period is included in the earlier notice.
My lord.
Tip line from bottom.
Lordship.
Right. Already included that period.
My lord.
And normally section 73 is more stringent and harsher.
4.
Section 74
Yes.
is more harsher than section 73.
No, 74 speaks about fraud.
But the period is same.
Period is same, but my
And
lord,
it is more harsher than section 73. Is it not?
Lordship.
All these grounds, fraud and other things, suppression of all these things are there. But if the subject matter is already covered in the previous proceeding,
my lord, the petitioner would have, should have, submitted a reply, to that effect, showing, what is similar, what he has already pleaded. He before the, earlier authority, pursuant to the earlier supposed notice. That he has not done, He waited, for the final order. Thereafter, after the final order, that too, after, 4 months, now he has approached his honorable court. That should have been his, he should have responded, placing all those facts.
Mr. Your conduct is not good.
My lord, this lordship.
Maybe right or wrong, there is a different second issue, but why you are waiting? Why should we entertain when we are not in a position to entertain?
On my part, I'm admitting, my lord, but lordship may kind
To us, how
subsection.
can we overcome the decision of GlaxoSmithKline
It would
and
be-
all other subsequent decisions?
Subsection.
No,
Subsection-
question is about giving a quietus to the litigation.
My lord.
Then when an appellate provision is there,
My lord.
why you have waited for the appellate period of limitation for filing the appeal to be over, to file a writ petition? Why? There requires a pre-deposit? That
Yes,
can be
my
one ground?
My lord.
Then okay, let us wait. High Court is entertaining
No,
left and right.
No, my lord. I've made a statement.
You first explain me how can the court under 226 can condone the delay.
My lord.
Have you proceeded with any civil proceeding in the meantime?
No, my lord.
Show us how can we condone the delay first? How can we condone the delay under 226 when the Supreme Court has admitted that not to speak of under Article 32, even under Article 142, we cannot condone the delay? Answer me that.
But lordship, I'm just.
Or I will answer.
No, my
You can seek the answer from the
No, my lord.
appellate forum.
I'm not on that, my lord. I have a time trying to.
No, that is the only question.
Section 6, my lord. It says when a
No, mister. First you say, Mr. Mishra,
Okay, lordship, lordship, allow me.
when the appeal period is over and when a person comes up in a writ petition after the appellate period,
My lord.
whether a writ petition can be entertained.
She may grant me some time. I will come back, my lord.
For your ready reference, 2020-19 SCC 681. And which has been followed by Supreme Court in subsequent issue. And otherwise, result is clear. You can seek an answer from the larger bench.
Sometime I will.
That is the most proper, because I am bound by this.
No, I'm not.
Yes, Mr. Gogoi.
Next week, lordship may take up.
Let it be on Friday, if at all he wants something.
Some
Friday.
difficulty, lordship,
Friday.
Some difficulty, my lord.
No,
Maybe out of-
Friday, no such.
My lord.
This court is not sitting in the next week.
Sorry.
I have heard you.
My lord.
R.S. Mishra, petitioner, B. Gogoi, pending counsel, Finance and Taxation Department, has sought for better learned counsel for the parties to address on the maintainability of the writ petition under Article 226 of the Constitution of India after expiry of the period of limitation, including the extended period of limitation under Section
107, my lord.
7 of the Central Goods and Services Tax Act.
2905.
Place the case on Friday.
Supplementary list, item 52.
Yes.
But here, my lord, SOCOS was issued on, my lord, 27/11/2024 for the financial year 2020-21, my lord, under section 73
Hmm.
for an amount of rupees 4,28,920, my lord. That was culminated into an order in original. It was passed on 24/2/2025.
Order?
But first SOCOS was issued for the financial year.
Just a minute.
My lord.
Demand comes show cause notice, page
My lord, page 25, my lord.
25, okay. Order in original,
But page 29.
29.
This pertains to financial year 2020-21, my lord.
Yes.
This was issued under section 73, my lord.
Hmm.
Thereafter, my lord, another demand comes SOCOS was issued, notice was issued on 39/2025. Page 38.
Page 38. 38.
No.
By the same authority.
My lord. No, respondent number 4, different, my lord. And lordship will find it was under section 74, my lord.
Hmm.
My lordship may see, my lord. In the earlier proceeding, my lord, financial year 2020-21 was already covered, my lord. The amount is same, my lord. For the financial year 2021, the lordship will find it, my lord. Lordship may kindly see page 26 and page 39, my lord.
Yes, 4,28,920.
For
But whether after 73,
my lord,
another proceeding,
my lord,
can be issued, proceeding can be initiated under section 74.
Not even
because going by your conduct for the subsequent year also,
my lord,
they have found that yes, you've been availing ITC
my lord,
beyond due date.
My lord.
Whether that can be good.
No, Lord Civil section 74, none of the ingredients is there, my lord. Lord Civil find it.
That I will not examine.
My lord.
If order has been culminated.
My lord.
Culminated.
My lord. Page 44, my lord.
Page
44.
33.
44 is the order in original, my lord.
So, why you should entertain?
Lord Civil see how much time they have given for response.
Why all this? This is an appellate remedy.
But Lord Civil see, my lord, for same, my lord, there can be two.
Go file appeal.
Lord Civil only see, my lord, duplicate demand cannot be raised, my lord, for my lord, same financial year, same thing, my lord.
Whether an appellate provision is there or not.
Appellate provision is there, my lord, but Lord Civil see, my lord, I cannot have to deposit twice, my lord, for same amount, my lord.
That
In
is
section 73, my lord, section 74 can only be invoked where there is demand, where there is fraud, misrepresentation of fact, suppression of fact.
We are not going into that. Appellate court is having jurisdiction to decide on all those issues factually, going into the factual metrics. Why should we entertain?
I'm not entering on the Lord Civil see, my lord, same amount, same financial year.
What is the law otherwise? When a statutory mechanism is available, it must be available.
My lord.
How many judgments you want to be cited? 100?
But duplicate demand is there, my lord. This is duplicate
100 decisions can be cited on revenue.
But Lord Civil duplicate demand if a Lord Civil.
Time is available, so I am not.
I got your point, Lord Civil.
Time is available. What is the time?
3 months. 3 months plus 1 month, my lord.
Pre-deposits, that cannot be a ground.
I'm not on my Lord Civil. If I prefer an appeal, my lord, I'm not on pre-deposit, my lord. But Lord Civil see, but there can be duplicate demand, my lord.
Which can be looked into by appellate forum. That is not a ground for entertaining all this now. There are strictures of the Supreme Court. What should we?
I thought that because they are actually double jeopardized, my lord, because of same financial year, same amount, my lord.
Yes, that can be exercised. Show us that lack of jurisdiction. Show us lack of jurisdiction. Show us lack of jurisdiction. Yes, show us.
Lordship will take a Friday also, on Friday, my lord. This also Friday only, my lord.
On what grounds writ petition should be entertained? When there is absolute lack of jurisdiction,
My lord.
when fundamental rights are violated, these are revenue after with an allegation of availing ITC,
My lord.
causing loss to the exchequer. Right. One is not available to raise that my fundamental right is violated. Third, virus, and when principles of natural justice. Shows lack of jurisdiction. Other grounds are not available.
My lord.
Yes, Mr. Whether it has jurisdiction or not.
No, Lordship, authority has jurisdiction to entertain the appeal, and Lordship.
No, appellate forum has jurisdiction.
No, Lordship.
Whether this
Original
authority lacks jurisdiction.
Lordship, whatever in this case, both the time the petitioner didn't appear before the authority. Both the order in past ex parte.
No, Lordship will see
It
page
has to be
43.
pointed out, sir.
43, my lord.
No, Mr.
My lord. My lord. I'm sorry.
Mr. That after receipt of the second notice, you could have appeared and pointed out to the authority, proper officer, that's look, you have been issuing this again for a second time.
My lord.
Then he could have made course correction if required. But you have not done. Your conduct is not that
Lordship may kindly see
appreciable.
page 43, Lordship may see the date of hearing, my lord. He's fixed the date of submission of reply on 33/2026, and date of hearing 33/26, and order was passed on 33/26, my lord. Was issued
Which one?
7, my lord.
Notice was issued on 30th September 2025.
The Lordship will see date of hearing was fixed on, my lordship, page DRC 01. Lordship will find it page 41, my lord. DRC 01 was issued on 27/3/2026.
Which one? Which page, sir?
Page 41, my lord.
Yes, please tell me. 27/3/2026.
No, Lordship may see page 43, my lord. Only 2 or 3 days was given, my lord. Page 43, my lord.
Page
43.
So did you receive it or not?
It was important. Skip my notice because only 3 days was given, my lord. 27.
So did you respond it or not?
My lord.
Later on also respond it or not?
My later on, order was passed on same 30, my lord. Lordship will see page 44. Order was passed on 33, my lord, itself.
Where is the second so cause notice?
Madam.
Page
Page
38.
38, man.
Page 38.
38, man.
Page 39. Just before you are called upon to show cause?
Yes, man. After this, my hearing was fixed on 27, my lord.
Within 30 days from the date of service of this notice. Huh?
The after notice was served, my lord.
It was on 39/2025.
Personal hearing was notified, my lord.
So did you respond to that?
It was not responded, and personal hearing was notified, my lord, after, my lord.
Huh?
Thereafter, personal hearing was notified, lordship. Personal hearing was notified on 27/3/2026, my lord.
But in between 39/2025
My lord.
to 27/3/2026, what did you do? What did you do?
That reply was filed.
Don't try to throw stones in others' glass house. What did you do?
That was my mistake, my lord. Lordship may take up Friday. Lordship, I could not satisfy Lordship may discuss.
No, I am not satisfied.
I got your point.
When the option of appeal is available,
My lord,
that is why I am not satisfied.
my lord.
Just because to avoid the pre-deposit and get an interim order of relief, that is not the way. Your conduct does not permit this court to enter in this kind of repetition.
That's only, that's only I was on duplicate demand, nothing else, my lord.
Same thing, RS Mr.
My lord.
SC Cal. Friday.
Much obliged.
Timing matters, items 7 and 8.
Well, put it tomorrow or some other day, Mr. Because it will take time. The other one.
Oh.
Mr. Biswas and Mr. Bora and Mr. Aishwarri. I'll go through it Friday. I'll go through it Friday. Okay. Thursday will be holiday. I'll go through it. Eta video. Sorry for the delay. Eta video, huh? Naam kita likhibo. A Biswas, petitioner in 8, I Chaudhuri petitioner in 7, M.K. Bora, respondent 4 in 8, H. Sharma, additional senior government advocate for the state respondents, and revenue, aforesaid. Friday.
Obliged.
And Bordeaux.
For admission, item number 18.
Please, Your Lordship. In this matter, notice served, but Sonari Municipal Board has not appeared, my lord.
What is the case about?
Is regarding, my lord, issuing notice by the Sonari Municipal Board for demolition of Kacha House, my lord, which was constructed in the year 1995, my lord, by taking permission and continued to pay the property tax.
Yes, madam.
If that chairman of our last official service has been completed on respondent number 3 and 4, my lord, and municipal board is represented by the chairman, my lord. Nobody has done
Just
what he
a
has
minute.
yet.
3 and 4.
Yes,
And
board is represented by chairman, ma'am. So
Asking him to demolish the bamboo tin house.
respondent number 1 and 2 have no role in this. Because
Service is complete.
nobody has turned out yet.
Nobody has turned up.
notice served
Then
twice, my lord.
let us see what is the case about.
Yes, my lord.
Petitioner Jyotirmoy Day.
Yes, Your Lordship. My lord, the petitioner,
Hmm.
along with another person, purchased a plot of land. Accordingly, my lord, mutated their name and
Plot of land from Dilip Kumar Shah. One katha.
one katha, my lord.
Registered sale deed
Yes, Your Lordship.
with Pinky Day.
Yes, Your Lordship.
Your nephew
Yes.
mutated their names. Made an application for seeking permission for construction Kacha house.
Yes.
Permanent house. Where is your first permission?
Permission is at page, my lord. At page 14, my lord, vernacular one.
Page 14.
14, 1.
আবেদনপত্র গঠিত উৎস অনুযায়ী
স্থায়ী কেঁচাঘৰ
ভাই
সজাত-
কেঁচা ঘৰ
Yes, Your Lord.
Yes, then
Then, my lord, the petitioner paying property tax time to time, my lord, till 2023, my lord.
house construction
In the year 2023,
two foot land reducing 17 feet. NOC from So your nephew ditched you. Ditched you.
Yes, my lord.
After giving
Yes, my lord.
NOC, withdrawn the NOC.
Yes, my lordship. And because of that,
I
my
am
lord,
perfect partition. Came to know from the Sonai Municipal Board. Where is the letter of the municipal board?
my lord,
26/4.
at page, my lord, 24, vernacular one, my lord,
Page
24.
So what is the ground that
Uh,
this notice is not sustainable?
My lord, I'm submitting that, my lord, the petitioner taking permission constructed the house in the year 95, thereafter paying taxes, my lord, only in the year 2023, it was restored, my lord, when he failed to got permission for construction of building, my lord. As it,
Yes, madam. Because his permission is that earlier, that page,
at page
earlier
14,
permission,
14.
page 14. Suppose he was asked to maintain 4-5 feet from boundary,
Yes, my lord.
plus 6 feet from government plot of land or
Yes.
from the public drain,
Yes, sir.
right? Otherwise, it was permitted. Then he was paying municipal tax, right?
Yes, sir.
So, what is the আগতীয়া অনুমতি নোহোৱাকৈ সাজিছে?
Yes, sir.
This is otherwise not correct. Privacy.
Prima facie.
And plus they are not appearing. We'll set it aside because notice, the precise case has to be set up in the notice
Lord.
as to why, in existence of an earlier permission, this house is illegal. And if it is constructed beyond the permissible limit, that should be indicated in a notice. Close, set aside this one. Heard Mr. M. Soikia, learned counsel for the petitioner, and Miss M. Bormon, learned junior government advocate Assam for the respondent number 1 and 2. Full stop. Para. In this writ petition, comma, under Article 220, comma, under Article 226 of the Constitution, the petitioner has assailed a notice dated 6/5/2023, issued under the hand of the respondent number 4, whereby the petitioner has been asked to demolish a bamboo-tin house erected in a plot of land, comma, covered by Dag number 419 and patta number 53, within bracket cost, comma, situate at village Sonari, village Dokhin Honari Gaon. Or Sonari or village Sonari? What is this? Village Dokhin Honari Gaon, Honari Revenue Circle, District Soraideo, and within ward number 4 of Unari Municipal Board, post of para. There is a case of the petitioner that the petitioner, along with and his nephew, comma, and the daughter of his elder brother, Pinky, Pinkey, Pinky Day, jointly purchased a plot of land from the plot of land measuring 1 katha covered by DAG number 419 and Patta number 53 Kho, situated at village Dokhin Hunari Gaon, Hunari Avenue Circle, District Soraideo. Subject plot by way of a registered sale deed number 189 dated 22/02/1995 from its erstwhile owner, post of, after registration of the sale deed, comma, the names of the petitioner and Pinky Day stood mutated pursuant to an order dated 1996, passed by the Circle Officer, Sonari Revenue Circle, in mutation case number 149 of 1994-1995, full stop. In order to construct a what is the kacha? English is what? Kacha. Kacha. Permanent house. The petitioner sought permission from the respondent Hunari Municipal Board in the year 1995 itself, and the respondent Municipal Board, by an order dated 4/7/1995, allowed, granted permission to the petitioner to erect a permanent kacha house on the subject plot by maintaining a distance of 6 feet from public drain, comma, if any, and government land, comma, if any, and also by maintaining a distance of 4/5 feet from the boundary of the subject plot. Full stop. Para, the petitioner has asserted that the petitioner constructed a permanent kacha house in terms of the permission dated 4/7/1995 of the municipal board, and he has been allotted a holding number by the respondent municipal board after assessment of house tax, comma, etc. Post op. Accordingly, comma, the petitioner has been paying the taxes, property taxes, as regards the permanent kacha house erected on the subject plot to the respondent municipal board regularly till March 2023. Post op. The petitioner has stated that as the condition of the permanent kacha house started deteriorated with afflux of time, the petitioner intended to construct a building on the subject plot, and for that purpose, he sought permission from his co-patadar, Pinky Day. Pusto. In the interregnum, there was encroachment inside the encroachment of about 22 feet in the subject land by the neighbor of the petitioner, which resulted in reduction of the breadth of the subject land from 19 feet to 17 feet. Full stop. Though initially the petitioner's nephew permitted the petitioner, expressed no objection to the petitioner's seeking permission for construction of the building on the subject plot. Later on, the nephew retreated from her earlier assurance. Instead, Pinky Day submitted an application before the Deputy Commissioner, Soraideo, seeking a direction to the respondent, Punani Municipal Board, not to give building permission prior to perfect partition of the subject plot. First of para. The petitioner has stated that it is in the aforesaid backdrop, the impute notice has been issued by the respondent municipal board. Full stop. The respondent number 3 and 4, as per order dated 23/4/2026 of the Lawajima Court, the respondent number 3 and the respondent number 4 were duly served with the notices. Notices were duly served upon the respondent number 3 and the respondent number 4. So despite service of notice, the respondent number 3 and the respondent number 4 have opted not to appear in the present proceeding. On a closer look, by the impute notice, the petitioner was directed to demolish the permanent kacha house on the ground that the petitioner had erected the permanent kacha house without any previous permission from the Punani Municipal Board. A perusal of the impute notice dated 6/5/2023 goes to indicate that the matter of absence permission was informed to the respondent number 4 by the engineer of the technical department of the board. Full stop. It thus transpires that it is on the basis of verbal information, the respondent number 4 appears to have proceeded to issue the impugn notice dated 6/5/2023. Full stop. The impugn notice, a notice of such nature must meet two requirements. Firstly, comma, the notice must indicate the precise case set up against the noticee, and the noticee must be afforded an opportunity of being heard. Full stop. As the petitioner has asserted that the permanent Kacha house was erected on the subject plot on the strength of the earlier permission dated so and so granted by the respondent municipal board, comma, the permanent Kacha house, which was directed to be demolished by the impugn notice dated so and so, appears to have been constructed after permission, full stop, to represent whether the impugned whether the house erected, permanent Kacha house erected on the subject plot a petitioner ought to have been given an opportunity, prior opportunity of being heard by the respondent municipal board. So with no such opportunity being heard to represent before the that the permanent Kacha house constructed on the subject plot is with permission or not. First off, does the impugn eviction notice, demolition notice dated 6/5/2023 does not meet the twin requirements which are required in a notice of such nature. First off, which the assertion of the petitioner are being not traversed by the authorities in the responding authorities in the so and so municipal board by their non-appearance, comma, the impugn notice dated so and so is found unsustainable in law. Full stop. It is accordingly set aside and passed. Full stop. If it is provided that if the permanent Kacha structure is not like the repetition is allowed to the extent indicated. No question.
Item number 19.
May it pleases, my lord. But this is also a challenge to a demolition notice issued by the GMDA, my lord. Matter was earlier referred to mediation by order passed by the ordinate bench, my lord, but the mediation was failed. And mediation
failed?
Yes, my lord. Mediation report is also there. My green flag is there, my lord.
Yes, what to do?
Lordship will have to hear the matter, my lord, if any date. Today also Lordship can hear, otherwise thought inconvenience, my lord.
Piece of property petitioner as per standing counsel GMC.
The GMDA.
Which were respondent of GMDA and Mr. UK Das, learned counsel for the respondent of board are present. Learned counsel for the parties have submitted that the mediation process has failed as and the mediator has submitted a failure report. In view of the same, in view of failure of the mediation process, let the case be listed July for
I pray for a hearing date so that my lord may pick up the matter.
Consideration. As the learned counsel for the parties have submitted that exchange of pleading is complete. Any earlier order, interim order?
Our interim order was there, my lord, from the first day. So lordship was pleased to pass an interim order, my lord, in this.
Thereafter?
Thereafter, it was extended.
Is the matter before appropriate bench. Depending on the same would pass. The interim order, if any, shall continue till the next.
Lordship, a hearing date may be fixed.
2107.
2107.
Item number 22.
My lord, here is a my lord of petitioner before lordship. They, my lord, inherited some land measuring 5 biga, 1 kata, 3 kata, 1 lesa. My lord, this portion of land, my lord, actually possessed by his deceased father. And after
On an earlier day, State Council said that he received instruction.
Instruction no, my lord.
On 8/9/2025.
That was not correctly sufficient, therefore. So therefore, lordship directed to take further instruction. But we are awaiting them.
11/6. Petition inherited 5 biga, 3 kata, 1 lesa.
after
1 kata, 5 lesa. Recorded. So some major part are not recorded in your case. That is your case.
while we are possessing,
It was shown to be government khas land, the other part. Why it was said so, that instruction has not been received.
this is a patna land, my lord.
I don't know.
My lord,
Mannaf says Pata land, Mr. Talja says government land.
my lord, I have annexed the patna, my lord.
Huh? Why they are saying, let them, maybe in the meantime,
My lord, we are
they have made
possessing,
government land. I heard Mr. A.
cultivating-
Mannaf land, counsel for the petition of Mr. B.J. Talja land, senior counsel, hosted by Mr. P.K. Medhi land, counsel appearing for the respondent number
3, 4, 5, and 6.
3, 4, 5, and 6 have sought for other 4 weeks' time to obtain instruction and to file the counter affidavit on behalf of the said respondents. And Bodulo respond number 1 revenue. Place the case on soils.
1507.
Item 23.
It's an illegal construction, my lord. Without any authority, this has been, my lord, construction was carried out by the private respondent. Now, my lord, this is the second round of litigation. Earlier, we had approached this honorable court, and my lord, the Barpeta Municipal Board was asked to, my lord, look into the matter and pass, my lord, appropriate orders, my lord. The lordship will find that order, my lord, at page 43. My lord, we were called for the discussion. I was pressurized, my lord, to make a compromise, and lordship will see what kind of order has been passed. Page 43, man. By this, has the lordship got it, man? By this, you are informed that in terms of the order of the Honorable Gauhati High Court, with regard to your allegations of 21/1/2025, both you and your adversary, Sri Vijay Kumar Saha, son of late Basanta Kumar Saha, Ward number 7, Borpeta Road, were asked to be present in the office of the undersigned on 19/5/2025 of the English calendar number calendar at 1 o'clock by letter number so and so. On the same date, both the parties were present.
But they were asked
no solution.
Not to take decision, but to mediate.
Mediate.
Is it the direction of the High Court?
Yes, yes.
Mediate?
No, not the direction to mediate, my lord.
Huh?
Not the direction to mediate. Lordship will see.
There were no decision.
Decision because the onus was put on me to make a compromise, my lord. And I'll come show, my lord.
So-and-so
Page 38, my lord.
So-and-so to examine the petition and take a decision. Petition. Okay, what is your
No, my
grievance?
my grievance is, my lord, this permission, which they're relying upon, my lord, was issued in 2022. Sorry, 20, my lord. It expired in 2022. Now, there was no permission, number one, my lord. Secondly, the side setback norms, nothing has been maintained, my lord. I have shown the photographs. And, my lord, lordship will see, my lord. The respondents now in their additional.
Where is the first? Take me to the first permission.
Yes, my lord.
You complained about illegal, unauthorized construct.
Yes, my lord. This is the, my lord, permission that page.
That is your adjacent plot.
Adjacent plot.
Okay.
Adjacent.
We are in the same family member, my lord.
That's true, my lord. That's not in dispute. Page 30, my lord.
From family members, Mahabharata started.
Yes. My lord, this is a permission. It's actually of 2020, my lord.
Which permission?
Page 30, my lord.
Page 30.
30, my lord.
30, yes.
30, my lord.
No margin.
No margin is given, my lord. And this.
So they were free.
No, my lord, in the diagram. It cannot be, my lord, free, my lord. Anyway, my lord, the diagram, the margins are given, my lord.
Recommended basement D+3 floor for approval. Checked. Diagram. This is what? Your side, Bidut Saha.
Bidut Saha, my lord.
How much? 3
feet, my lord.
3 feet.
3 feet, my lord.
So 3 feet is there or not?
No, my lord. I have made a statement, my lord. That is one. Second, this permission, my lord, lapsed in 2022, my lord. It's for 2 years. It cannot, my lord, be beyond 2 years. Then, my lord, then came the new, my lord, rules, my lord.
That is a different matter. 2020. Where have you said 2 years? Where from you are saying?
My lord, that it after 2 years it goes, my lord. That's as per the law, my lord.
Permission is valid for 1 year.
Valid for 1 year, it can be extended up to 2 years, at the most, my lord. Yes.
So when the construction started?
Construction started sometime in 2025, my lord. 25, my lord.
2025.
25, 24 last part, my lord. First week of 2025.
It was extended again.
Maybe extended. I don't know.
I'll come to that, my lord, how it was extended.
2025. Okay, you prefer the writ petition. 2025 or earlier? 2025.
I prefer the first writ petition, 2025. After this construction started, my lord, since, my lord, they are not maintaining the setbacks, I came before this honorable court, my lord. Initially, a stay order was passed, my lord, by the board. That was not, my lord, complied upon, and therefore we had to come before this honorable court, my lord. 1652/2025, this is the first writ petition, my lord, page 36.
Now he has submitted another permission.
Exactly, my lord. That is his claim.
Where is the boundary setback? Same. Or different?
He's saying same, my lord. He is saying the similar. He is actually, my lord, what he has done, my lord, is that he has produced this. My lord, should we kindly time to take his affidavit, my lord? That will make things clear.
Same 3 feet.
3 feet, my lord. But then, lordship, you see how the permission, my lord, has been, my lord, extended, my lord.
Now, show me either in 2020.
Yes, my lord.
Or 2000. This was when? Next permission was when? Extension?
My lord, they say it's on 2024.
2024.
But the board is silent.
No, tell me, board is silent, okay.
My lord.
What is the setback under the law?
Under the setback law, setback, my lord, is 1.8 meter, my lord. On the side, my lord.
Which law? First, you tell me.
Now, my lord, 2022 law, my lord. The Assam Unified Building Construction Regulation.
You tell me, under 2020, which law was prevalent?
My lord, that point of time, the 2010 law was prevalent, my lord.
What was the setback?
2010 law, my lord, setback.
Which book?
My lord, I'm referring to, my lord, building construction. This book, my lord, I'm referring to, my lord.
Who represents municipal administration? Or municipal board?
Board, well, it's a corporate or municipal board, my lord.
Mr. Bhattaji.
No, I got it.
Name has been shown in the cause report.
Yes.
Then why the council have decided not to attend? Why we're examining this for last 10 minutes? The concerned municipal board is not here.
Because the problem is with us that
They are perhaps they think that they are not litigant, they are mediator.
They're mediator.
Yes, Mr. Sharma. Otherwise, I am directing the municipal administration to place the setback existed under the bylaws in 2020 and 2024.
And secondly, my lord, whether how this permission was renewed, my lord, that's lordship will see, my lord. This permission could not
That he cannot say.
that he cannot say.
He cannot have
That
access
the-
to the file.
Yes, sir. Yes.
But municipal administration can say definitely what are the laws as regards setback or margin. Yes, Mr. Sharma. And Mr. M. Dr. Lance, Senior Counsel, appearing for the petitioner, stated by Mr. So-and-so, L. Lekal, Learned Counsel for the petitioner, Mr. H. Sharman, Learned Additional Senior Government Advocate, Assam, for the respondent number 1, 2, and 3. And Mr. S.C. Visas, Learned Counsel for the respondent number 6. Who is the 7? Full stop.
7 Vice Chairman.
Though the
By
name
name,
of the Learned Counsel for the respondent number 4 and 5 is reflected in the cause list, comma, the Learned Counsel is absent today on call. Full stop. The issue raised by the petitioner herein is with regard to unauthorized construction of a RCC building by the respondent number 6 in a plot adjacent to the plot of land of the petitioner without maintaining the minimum distance of the building from the boundary wall. More particularly, comma, which side? Eastern or
My lord.
which side?
My lord, in fact, all the sides, my lord.
No, you are concerned.
My lord, I have got two boundaries with him, my lord.
Okay.
My lord, it will be on the, my lord, yes, my lord, made a mention, my lord. Margin on the east, my lord, and south, my lord.
To the east.
We are considering east and northern boundary, my lord.
East and
Northern boundary, my lord.
east and north.
North, my lord.
Eastern and northern south side of the plot of land of the respondent number 6.
No, it'll be my plot, my lord. So it'll be, my lord, his will be west,
Okay.
then, my lord.
Or the petitioner's subject, petitioner's plot of land.
Yes, my lord. East and north of mine, my lord.
The respondent number 6 is shown to have obtained a building permission from the respondent so-and-so Borpeta Road Municipal Board on 2/3/2020 with a validity period of 1 year, WEF 25/02/2020, and another permission on 26/7/2024,
With effect from
whereby validity
2 years.
has been whereby the permission granted was revalidated for another 2 years, WEF 26/07/2024. Post of. It is a contention of the petitioner that the respondent number 6 had started construction of the RCC building only in the year 2025. Post of. Para.
And well, this revalidation is not permissible in law.
We are not.
My
We are not entering into that.
my
In the absence of the respondent number 4 and 5, comma, the respondent number 2 or 3, 1 shall file an affidavit. Is directed to file. Is requested to file and is directed to file an affidavit.
Okay.
To bring on record the building bylaws which were applicable in areas falling under municipal boards like Borpeta Road Municipal Boards in the year 2020 and also in the year 2024, and also the minimum setbacks and stroke or minimum distance to be maintained for a RCC building within bracket G+3
Yes.
from the boundary wall on each side. Postal. Though the respondent number 4 and 5 is absent today on call, the respondent number 4 and 5 are also directed to file an affidavit on the aforesaid points by the next date of listing.
They filed the affidavit, municipal board. Municipal board has already filed.
Have they highlighted this?
No, nothing.
No, this
nothing,
point is.
nothing. It's a cryptic affidavit, man.
Knowing fully well I have passed this order. At least the case on sales. After 4 weeks, after July, after vacation.
My lord, only thing
Summer
is
vacation.
water is dripping into their, my lord, and house.
Okay, June.
22nd June.
No. Kindly, this which will be there, I will be there, my lord. That's why I may excuse. Let it be on any other day.
24.
No. My lord, let it be on 26th, my lord.
No.
My lord, after 26th.
Don't stress the court just before the holiday. Don't stress the court.
After 26th, my lord. That's
Don't
the
stress the court on the last day of the court.
I will remain busy there. That's the problem, my lord. The already program has sorted out.
Then it goes to July.
My lord, the only difficulty is that the water is, my lord, falling, dripping into the, my lord, the house.
15/7.
15/7.
Obliged.
I cannot take up all these cases on the last day before vacation, mister. You will come up with permission to move unlisted for 3-4
No, my lord, I will.
expedition.
I'm not pressing for the last day, in any case, my lord.
Next.
Item number 24. In this case, my lord, on last occasion, the government advocate was obtained time for filing my lord, counter.
What is the issue?
My lord, we filed election petition in the, my lord, before the election tribunal. Then he filed an application under, my lord, order 11, my lord, rule 14 for calling some records from the, my lord, deputy commission. That was a rejected. And against that order, my lord,
My lord, affidavit is almost ready, my lord. Only it will go for vetting.
DA Kayum, Learned Counsel for the petitioner is present. Mr. Ann Das, Learned State Counsel, Learned Junior Government. Some appearing for the respondent number
2, my lord, 2.
2 has submitted that the draft affidavit has already been prepared and the same and I sought for listing of the case after 2 weeks to file the affidavit on behalf of the respondent number 2 in the meantime, post op.
On behalf of 3, I have filed.
Already filed, my lord.
Ms. M. Mormon, Learned Junior Government Advocate, Learned Counsel for the respondent number 3. Ms. A.B. Castro, N.B. Castro, Learned Counsel on behalf of Mr. R. Dubey, Learned Assam Standing Counsel, Assam State Election Commission for the respondent number 1. And anybody for 4?
4 service has completed, my lord, but
Okay.
he has not been.
List the case on friends.
1706. Item 25.
May I please, Your Lordship? My lord, the issue is, my lord, regarding my sale permission of land, my lord. What happened when the petitioner for medical agencies sold a land to one Simapal and applied for sale permission before the authorities, my lord, through online process, my lord, online Shava Setu. That application was rejected. Sale permission was rejected only on the ground that, my lord, they took two ground, my lord. One is that the land revenue was not paid up to date, and second, my lord, geotagging photograph, my lord. Whereas the land revenue was paid up to date, my lord. Your lordship will find page number 21. I applied for sale permission in 25, and land revenue was paid for 24-25, my lord. So land revenue was paid up to date, my lord. And secondly, my lord, so far as rejection of my application on the ground that a geotagging photograph is required, for taking the geotagging photograph, my lord, the concerned lot model is to visit the land, my lord, is to visit the plot of land, and he will have to take the photograph of both the buyer seller, including himself, my lord. That's what my repeated request, my lord. He did not go to the land, my lord, for taking the photograph.
Yes, Mr. Sharma.
Lordship. We have filed our affidavit wherefrom it reflects that only these two grounds, Lordship. One is that they have failed to submit the geotagging photographs and the land revenue receipt.
He says he has submitted. You have said
Lordship,
he has not submitted.
Not submitted.
So
So,
what?
Lordship, once it is rejected in the portal, Lordship, it cannot be reviewed. So let him file a fresh one.
And then we have dispute. How can we address this issue?
My lord, a rejoinder has been filed today, and
Saying what?
that
Disputing that.
Yes, Lordship. According to him, he has the Latmondal.
Then it is disputed question of fact.
Yes, Lordship. That is why let him file a fresh one, Lordship.
Or if the provision of appeal is available, he file appeal. What to do? We cannot decide disputed question of fact. You have said you have submitted land revenue. They are saying not.
it is a part of record. In fact,
No,
Mal.
So
read code. Don't argue this point.
Mal.
We decide on the basis of affidavits.
Lordship.
Now you say I have submitted.
Mal.
They have said
No,
not submitted. Whether we go, this is not an appellate court.
Mal. No, my lord.
Go before the appellate court. You have an appellate court, I think. Not. Where is the submission? Let us see. Application. What is the service?
Application.
What is the service?
Yes, Lordship.
Prayer.
Yes. Appeal provision is there. You may raise an appeal at so and so, though if the
Which
service
page?
is not
Which
there.
page?
At page 17.
17.
Yes, Lordship.
Oh, this is composite land sale transfer. There is an appellate provision. Go and appeal, or otherwise,
Raise
if
an
the
appeal before.
appeal period is over, then you file a phase one. Then follow provision. Don't come here. Land composite land sale transfer আছে নেকি চাওঁ? Third, Mr.
MS, my lord. Lordship may issue direction, my lord, so that I will apply afresh, so that, my lord, the authorities, my lord, they will, in the time frame, my lord, they will grant the permission, my lord.
Mr. M.A. Islam, learned counsel for the petitioner.
The direction is not required, Lordship, because he has got the right to file a
And
fresh.
Borderline revenue for the respondent number 1.
Myself, 2, 3, and 4, Lord.
And Mr. H. Sharma, learned additional senior government advocate for the respondent number 2, 3, and 4. So, para. The petitioner has stated that she is the lady, right? She is the absolute owner of a plot of land measuring 2 kathas, 2 lessers, covered by dag number 92 and KP Patta number 90, situated village Hakama Part 2 within bracket town Bilakipara Revenue Circle, Dhubri, District Dhubri, sublet plot, and is in its possession, full stop. As the father of the petitioner, is a kidney patient, and for his treatment, the petitioner was in need of finance, the petitioner entered into an agreement for sale of land with a with an intended purchaser on 14/9/2025 for a total consideration for an agreed consideration of rupees 12 lakh. Post op. The petitioner has stated that she has already received an amount of rupees 10 lakh from the intended purchaser. Post op. Thereafter, the petitioner applied after the agreement for sale of the land after execution of the agreement for sale of land on 15/9/2025 and receipt of part consideration of rupees 10 lakh, the petitioner submitted an application through Seva Setu portal on seeking the service, composite land sale transfer. And the said application was received under acknowledgement on 18/11/2025 with an indication to provide either to extend the service or to reject it with reasons within a period of 45 days. Post op. In the respondent number 4 has filed an affidavit in opposition on 14/5/2026, wherein it is stated that on 31/12/2025, the application of the petitioner for the service composite land sale transfer has been rejected by the respondent number
Circle officer.
4 on the basis of a report received from the land record assistant LRA, wherein it was cited, wherein it was reported that the petitioner had failed to submit the geo-tagging photographs and the land revenue received. Post op. The rejection of the petitioner's application on the aforesaid two grounds, on the said two grounds, has been objected to by Mr. Islam Learned Counsel for the petition on the ground that the petitioner had submitted up-to-date land revenue deposit receipts along with the application, and the rejection of the petitioner's application on the said ground is not tenable. First off, he has further submitted that insofar as geo-tagging photograph is concerned, it is after submission of an application, the land revenue staff from the office of the respondent 4 had to visit the subject plot and thereafter to take such photographs, and it is not incumbent on the part of an applicant to submit any geo-tagging photograph along with the application. It must first of in view of the contrary stance taken by the petitioner and the respondent 4, As per number 4, who has rejected the application on 31/12/2025, the disputed questions of fact have arisen for consideration post of a writ petition. This court, in exercise in its rich jurisdiction, does not sit as an appellate court and has and does not go into the question of fact in its certiorari jurisdiction. So, I mean, such view of the matter, in view of the disputed questions of fact, it is not
My lord,
possible to decide.
well, page number 21 of my writ petition. Lordship, my lord, page number 21 of my writ petition. The land revenue receipt, my lord, is a part of my writ petition, my lord.
I have already mentioned.
Lordship.
Did I not mention up
Yes.
to that revenue receipt?
Yes, man.
Then why you were? After that, I have come to a conclusion. It is post of it is difficult to no dispute question of fact. Such a jurisdiction. It is only the decision making process, not the decision, which can be looked into by this court in exercise of its power of judicial review. Post of adequacy or sufficiency of the reason for dismissal of the application does not fall within the purview of the power of judicial review. Post of be that as it may, as the application of the petitioner for composite land sale transfer has been rejected on the aforesaid 2 grounds, and it is still open for the petitioner to submit a fresh application seeking the notified service, public service, composite land sale transfer, the writ petition is disposed of with a direction to disposed of reserving the liberty is closed. The petitioner a notification by notification dated 11/11/2022. The Revenue and Disaster Management Department in the state government has declared the composite land service transfer as a notified service. The notification has been issued with a view to provide delivery of public service to eligible citizens within the stipulated time limit and others as under. Etu para 21 এখন লিখে put করে দিব। তাৰপিছত 22 লিখিব। As it is open for the petitioner to file an application afresh, the petitioner, it is open for the petitioner to submit an application afresh, and in the event a fresh application is filed by the petitioner along with all the requisite documents, the respondent authorities shall process the application strictly in terms of the provisions of the Assam Right to Public Services Act and the notification dated 11/11/2022 of the Revenue and Disaster Management Department.
Hello.
Item 26.
Land of the petitioner's father was acquired by the.
Yes, who was to file affidavit?
Lordship, I think the direction was given to us, Lordship,
After the 30th of March.
with certain directions, Lordship.
I ask you, Ahmed, for a petitioner. Union of India? Anybody? Yes, Miss Baudelaire and Baudelaire. Revenue 2. Mr. Dotto.
S Mitra, my lord. S Mitra.
S. Mitro. You're for?
3. Respondent 3.
S. Mitro, learned counsel for the respondent 3, and Mr. H. Sharma, learned
4 and 5.
additional senior government advocate for the respondent 4 and 5 are present. Okay, Mr. Sharma has sought for and is granted how much time? 4 weeks time
Lordship.
to obtain necessary instructions and to file the counter affidavit on behalf of the said respondent number 4 and 5.
Lordship.
Yes, Mr. Mitro, you want to file anything?
My lord, we'll file affidavit after they file their affidavit.
No, there is no other way.
My lord, because
Installment, they will file and you will file.
happened with my lord.
Mr. Mistro, learned counsel for the petition is also granted 4 weeks time to file the counter affidavit on behalf of the respondent number 3. Lays the case on slips.
1507. Item number 27.
My lord, this is a case, my lord.
Hmm.
They are seeking relief under 2F of section 111, my lord. This is, my lord, education, the
Minor
childbirth,
Minor marriage.
But as per the 62 rule 62, the district commissioner doesn't have a power regarding minor marriage, child marriage.
Who has the power?
My lord,
Who?
as per my lord 127, they have to go to tribunal, my lord.
Have you gone through all the decisions?
Those decisions I am, my lord,
Huh?
preparing.
First,
decision.
Rule 62,
My lord,
virus of Rule 62
my lord,
was challenged,
my lord,
right?
my lord,
That has to be challenged before a division bench.
my lord,
That was challenged.
my lord.
That has been, virus has been upheld. Then it was challenged before the Supreme Court,
My
right? That SLP was dismissed.
lord,
Then second round, that Motiur Rahman,
my lord,
right?
my lord.
The second round started. Again, Rule 62, where Javed and the virus has been upheld. Then it went to division bench.
My lord,
Division bench dismissed the appeal, upholding the
my lord,
single bench judgment. Thereafter, they went to the Supreme Court.
my lord.
That was affirmed. So, in that view of the matter, so is it still open for you? Definitely, you'll argue so that I can hold it.
My
Now, the question is what? You want to say that this 62, under 62, Deputy Commissioner is not empowered.
my lord.
Let us see.
My lord, they are saying, my lord, that district commissioner is not doing anything. That is why I have submitted on behalf of district commissioner.
No. District Commissioner says what? Mr. Sharma?
I have not received any instructions.
No, I'm just.
62?
62, rule 62 is the. my lord,
First, give 111. Let us see.
Yes, yes,
Disqualification is at 111.
my lord.
Let us see. Which one? Under age?
2F.
2F. Right. 2F. Then what is the rule?
Rule 62.
62. Which particular rule?
My lord, I'm just saying. A, I think. At page 229, if lordship is holding the same book, my lord.
Four A.
4C is there, my lord.
Mhm.
4C is there, my lord. Sorry, my lord. Yes, 4B and C is there, my lord. Of- Overall, affidavit disseminate.
62-4.
62-4A, B, C, my lord. B and C is the procedure is there.
And this has been held to be that petition is not maintainable.
My lord, district commissioner has power, my lord. Sorry, my lord, I was wrong at the time. I've just gone through it, my lord. As per 4C, district commissioner has power.
Yes.
So I apologize for my earlier submission, but 4C is there, my lord. So now the private respondent, they have to, what is their stand and deputy district commissioner's stand is very important, my lord.
Yes.
I need some time, my lord, to file affidavit in opposition.
Now, what the petitioner is alleging?
Lordship,
Petitioner is alleging what?
petitioner Lordship, he was one of the
He is alleging that respondent by 8
eight
had undergone child marriage.
child marriage.
And it is pending before the district
Yes,
commissioner.
he filed an application before the district commissioner. Then that application was forwarded to the co-district commissioner Lordship, and the co-district commissioner has held a hearing on that. And Lordship may come to page 33. There is a finding, Lordship, that there was child marriage, and he is disqualified.
What is it? The process is pending.
My lord.
Process is pending.
Yes, yes, my lord.
It has not been finalized.
He has not been finalized, Lordship.
So, we are into it. Let them, district commissioner, he has to make a report. But it is by specific provision.
Yes, Lordship.
District commissioner has been given the power,
Oh,
authority and jurisdiction to decide on the issue. So your grievance is that he has not yet finalized the proceeding.
because this order of the district co-district commissioner is of 25th of August 25, Lordship. In this petition, we are just seeking for a mandamus, Lordship, to direct the district commissioner to finalize it.
And which decision you are citing on that day?
My lord, there are two judgments which are already appeal has been filed pending before division bench. Those judgments says, my lord, in case of improper acceptance, district commissioner doesn't have power. If the
Appeal is appeal.
yes, yes, fine.
And are you a contesting candidate or?
Yes, yes.
Contesting candidate.
Oh, you are contesting
Yeah, he
candidate.
is not a voter.
He was a contesting candidate.
You are contesting candidate.
Yes.
Even then also law
No, no.
is there, Lordship.
No, locus is different.
Yes.
Every case is different. Election law is different. Unlike you could have, you are a defeated candidate.
Yes, Lordship.
Then the situation is different.
Different, yes. That is the submitting one.
These provisions are meant for voters, electors, not the failed candidate.
Right.
Failed candidate can seek cancellation of election by way of an election petition. Electors can,
Yes,
that has been already discussed in my
yes, yes.
Electors can, and that has been upheld by Supreme Court. Then there is another decision of Supreme Court. The electors cannot be remediless. But so far as a contesting candidate and a failed, defeated candidate, it is for him to, he cannot expand the jurisdiction. Because the election petition is only can be filed by a contesting candidate.
Yes.
We'll keep this question of maintainability of this writ petition open.
129.
Well,
Very specific.
and thereafter by an notification,
Yes.
you have to address it on the point, maintainability of the writ petition. In absence of filing of any election petition. Heard Mr.
M. Ahmed.
Learned Counsel for the petition. Who is for whom?
I'm for PNRD.
As Dr. Standing Counsel, PNRD for the respondent number 1557. Mr. H. Sharma, Learned Additional Senior Government Advocate Assam for the respondent 2 and 3. Ms. S. Kotoki, Learned Standing Counsel ECI for the respondent 4. And Mr. A. Hussain, Learned Counsel for the respondent number 8. First of para. In the Panchayat general election held in May or June?
It was held
In
June, I think.
May 2025.
25.
The petitioner and the respondent number 8 submitted their nominations for election as a ward member from ward number 7 within bracket Borguli of Lalpul Gram Panchayat. District Dorong. Full stop. When the results were declared on 14/5/2025, the respondent number 8 was declared elected. Full stop. Subsequently, the respondent number 8 was selected as the president of Lalpul Gram Panchayat. Full stop. Para. The case of the petitioner who was the defeated candidate, is that the respondent number 8 has incurred disqualification to either to be elected or to continue as a ward member and consequently president of a Gram Panchayat in view of violation, in view of incurring the disqualification under section 111 2 within bracket F of the Assam Panchayat Act, read with section rule 64
62(4) ABC.
4 ABC of the Assam Panchayat Unified Constitution rules 1995 as amended. As amended by Assam Panchayat Constitution E2. My এখন নাই নাই দেখোন পুৰণি নেকি
Last amended on 28 June 25.
পুৰণি নেকি নতুন নতুন
This was the latest, my lord, green color.
Some concerns amendment.
Because this amendment is necessary. Assam Panchayat as amended up to date. A question of maintainability of a petition has been raised on the ground that the petitioner as the defeated candidate did not prefer an election petition before the under section 129B read with section 127 of the Assam Panchayat Act 1994 as amended post of Mr. Amit, learned counsel for the petition, has sought some time to address on the maintainability of the petition and as well as the locus of the petitioner to prefer the instant writ petition. Find out the judgments.
Otherwise, Lordship will give me liberty, Lordship, I'll approach the tribunal again.
What? No charge.
That division bench order is there, my lord.
There is a strict period of limitation.
Delay cannot be condoned, my lord.
This court has also held special law, special period of limitation. If you have not availed the opportunity, you are out. See response number 8 as a precedent for next 4 years. You have no other option. Next. Did you next week to next week you? Next week nalag.
4 June, 4/6.
Highly obliged.
Item 28.
On 25/7/2025, Lordship, some fraudulent transaction took place in the account.
Financial failure from loan.
I got the instruction.
Finance company. Loan was sanctioned. Finance company. What does it indicate?
Well, one more report I have got from my lord, this inquiry made by the OC and it written to the my lord.
Instead of going against the fraudster, you are going against the petitioner or what? Huh? Are you not equipped with the
It says, my lord, if your lordship come to the second pair below one, my lord, in this connection inquiry.
Huh? That is what I am asking.
Yes, ma'am.
What he is doing?
That's
This Rupohiyar police station officer in charge, what he is doing? He says, the petitioner is saying that the case has been transferred to Rupohiyar police station. Is it so?
Yes, Lordship.
Which order?
Annexer 4, Lordship, page 23.
Annexer 4.
Yes, Lordship. Page 23, Lordship.
This is by Cyber Police.
Yes, Lordship.
Cyber Police of which one? Assam?
No, Lordship, it is from National Cyber Portal, Lordship.
This has been transferred.
Yes, Lordship.
And
Lordship, after filing the complaint, Lordship, page 22, Lordship, the amount was again deposited to the
that I have now in your bank it is there or not?
but bank is not giving any.
Which for the bank?
And for the bank.
Yes.
Actually, the amount is for temporary credit. As for the RBI rules, if there's any complaint based on the cybercrime, the bank gives the temporary credit till the investigation. I have to file a detailed affidavit regarding this, and if it is found that there is no negligence on part of the bank, then the amount has been again taken reversed. That's as far as
Mr. Das,
my lord.
it looks like he is misdirecting himself. The OC. Maybe you get the instruction from somebody else. I don't think he has the capacity to investigate such kind of investigation, Rupohiyar police station.
But I'll,
Or accustomed with land dispute.
my lord, I'll do the needful, my lord.
He is not accustomed to do Jamtara kind of thing.
Senior superintendent of police, my lord.
Nothing is going to be served.
Only, my lord, some direction. That will serve the purpose.
I had Mr.
Yes, Lord.
S. Alam, learned counsel for the petitioner, Mr. N. Dust, and Junior Government Advocate Assam for the respondent number 1, 2, and 3, and Mr. M. Smith, learned counsel for the respondent number 4. First of Mr. Smith, you file an affidavit. Otherwise, how can we know? Learned counsel for the respondent number 4 has sought for and is granted. She is trying to file an affidavit on behalf of the respondent number. File the counter affidavit on behalf of the respondent number 4. First of Mr. Das and Junior Government of Assam has placed some instruction in deference to
Inquiry conducted.
in deference to the order dated 27 to 2026 and 6/4/2026. First of the instructions received by Mr. Das has been placed before the court. Full stop. It is the case of the petitioner that the cyber complaint lodged by the petitioner was transferred by, what is the full form? NCC?
National Cyber.
Full form National Cyber?
reporting portal.
No.
Huh? The Cybercrime Reporting Portal. Transferred the complaint of the petitioner to Rupohiyar Police Station for investigation on 9/8/2025. Post up from the instruction placed by Mr. Das received in the form of an office letter dated 25/5/2024 from the respondent number from the
Office of Superintendent of Police.
Office of the Superintendent of Police, steps, no effective steps appear to have been taken from the end of the respondent number 4 and the respondent number 3 and the respondent number 4, full stop. As per the instruction, after
Seeking specific reason for freezing the bank account.
it has taken them for 10 months. The inquiry officer proceeded to the respondent number 4, proceeded to the Mission Market Branch HDFC Bank pursuant to registration of Rupohihat Police Station General Diary entry number 13 on 20/03/2026 and served a formal notice under section 94, B and SS to the branch manager Mission Market Branch HDFC Bank, seeking specific reason for freezing the bank account of the petitioner. Full stop. From the instruction so placed, it appears that during the period from 9/8/2025, when the complaint was transferred by the NCCRP to Rupohihat Police Station till 20/03/2026, no effective steps have been taken from the end of the respondent number 3 and 4 to investigate into the matter. Therefore, Mr. Mr. Das has sought for further 2 weeks' time to obtain instruction as regard the status of up-to-date status of investigation of the case. Release the case on so and so.
1506.
For investigation, okay. I have to rise. Can you place the date when you want the cases, right?
Hello. Those instructions. It will be part of the.
No. The instruction placed by Mr. Das is returned. Yes, the other cases. I have already said, I have already directed. In the previous order also it was mentioned. Further 3 weeks' time. Yes, other cases.
15/6.
You can take the date. Wherever interim order is there, please mention. I will extend.
Item number 29 may be taken on Monday.
Not possible. This is not possible. This next Monday. Next Monday. Okay. Give the date. Not in this week, any date in the next week. Please give the dates.